ఎవరు జనరేషన్ చేస్తాను అది చూసుకోండి.
National terrorism, as we call the global terrorism, it has got very serious effects on the society, affecting the rule of law, affecting our basic rights. It has adverse effect on the undermine our pluralistic civil society even, aims at destruction of the democratic basis of the society. So it has got extensive ramification in the society, this terrorism. But at the same time, how we shall meet this terrorism? So the global terrorism, counter-terrorism activities. We are very much worried about the counter-terrorism activities. In the name of meeting the terrorism, the great values of human rights also is seriously eroded. There is one problem which we are now the world at large is facing. And powerful countries, powerful nations, they will say we are only meeting the terrorism, but in the name of that, violations of basic rights, they are not, those who are affected by or those who are suspected to have committed terrorism, they are detained for long period. Both suspects and allegedly suspects, people are incarcerated in jails for longer period. They are very, very coercive. Interrogation is there. Various types of torture is inflicted on them. All these, to a great extent, could be avoided. At the same time, meet the terrorism to find out solution for the terrorism. So this is something which we see in many other countries. They don't reveal the number of persons detained. They don't reveal the nature of the violation of basic rights. Even in some other countries, this telephone tapping and all great inroad into the privacy of your life, all being done very clandestinely. They are given all these permission is given to all secret agents, and nobody knows what is happening in those countries. India is luckily, we are in a very good situation. Of course, there may be some violations of basic rights in India also. Important subject which people would like to know about this subject, how to we have to find out some solution to at least a mode by which the least problems are caused to the great values of human rights. The human rights is to be protected and preserved. They are inalienable rights which one has to enjoy, basic freedoms which is human rights. So our time is limited, so I hope the speakers will come straight to the point and talk on the subject, taking the minimum time required, so that we can have a very good discussion on this subject.
My fellow speakers, of course, Professor Shadrick will come later on, Sir James will come later on, Mr. Wasim Numani will be joining us shortly. I have two more fellow speakers on the dais, Mr. Jeremy Payne, Mr. Harpreet Singh. Honorable participants in this conference, ladies and gentlemen, I think I am speaking on this subject quite often. I remember speaking earlier here in this very committee room and also at London where Dr. Balakrishnan was chairing the conference. And I feel this is an appropriate how we have to contain, control, and eliminate terrorism through legal system. But at the moment, America is adhering to modes of some sort of terrorism by taking the detainees away from their legal jurisdiction, taking their detainees of prisoners of war far away beyond the legal jurisdiction of their nation or their state of Goa. I'm happy to inform you, just 2 days back, when I was in Delhi, I received a message on my mobile that a small state of Goa also started a state human rights commission. So that was to show that our country is a country which adheres. Paper here, I think it will be most appropriate for me because it is a very complex. The nation was formed in 1845. It took 3 years for the delegates, the national delegates, to the United Nations to life. Whether the state is as a guarantee for the safety of life, I think this is also debated in the legal fraternity. In the contemporary world, communities facing imbalance in development in a biased, unipolar world, certain segments still trying hard to gain economic freedom due to rampant hunger and poverty. If you scan the globe for the last 62 years, for the example of genocide, repression, torture, wars and rape, starvation, death, environmental degradation, and terrorism, the answer will be all alas. It's high time the nations of the world come together and ponder whether the world body has greater proactive role to play in fighting terrorism in its all forms. It is not high time that the world body act fast and see laws are framed and courts are established on the pattern of the war tribunal with international jurisdiction? If not, this world will face its doomsday at the hands and at the altar of terrorism. Ladies and gentlemen, I am so happy for having your time and your patience. And I thank the chair for giving me extra time. Thank you very much.
International law and domestic law have to face the very serious challenge of balancing between national security interests in the face of terror and the important value of protecting human rights of suspected terrorists. International jurisprudence has shown in the beginning of this century, after 9/11 attacks, complete acceptance of executive and legislative emergency measures against terror. However, in later years, courts showed a very strict approach toward executive and legislative counter-terrorism measures. The dilemma of shaping a proper attitude toward people of different cultures and religions has been made greater by this challenge because of the security threats and terror violence of attacks that were committed by international terrorist groups. In recent years, a dialogue is taking place between the legislature and the courts on the legislative measures which were introduced to fight the terror organization all over the world, particularly after the 9/11 attack. In this context, the courts had to deal with judicial review of security decisions such as the detention of unlawful combatants, administrative detentions, target killing, special investigative procedures and the like. The general pattern in most jurisdictions has been to broaden the scope of judicial review of executive decisions in matters of national security, while in the past the scope was narrower, limited to procedural deficiencies or jurisdictional deficiencies. Today, in recent years, the judicial approach has changed and courts do not hesitate to review executive and legislative decisions in national security matters. This is noteworthy that in spite of the increase in terror attacks in recent years, the courts demonstrated readiness to review administrative discretion in security measures. In the last decades, numerous countries were subjected to terror activities. In addition to the 9/11 attacks in the United States, attacks were directed at train stations in London 2005, in Madrid 2004. In Asia, attacks took place in Bali, and of course we are sitting here in New Delhi, and India was subjected to terror attacks last week in Varanasi, and of course we all remember the vicious attack perpetrated against Mumbai, including the Taj Mahal hotel. In the first part of the last decade, immediately after the 9/11 attacks, as I mentioned during the plenary session, the courts were impacted by the grave results of the attacks, and legislator enacted emergency measures, and the executive very much exercised these powers, and the courts were in fact demonstrating deterrence. In the second part, we can see that there is less acceptance and less deference to these measures. Let me just review very quickly, within the limit of time, a number of cases which I already mentioned, but I will give you more details this time. In the United States, the government policy was very active after the horrific terrorist attack on 9/11. And the first, the Patriot Act of 2006, Military Commissions Act, which allowed much more invasive and abusive policies against human rights. In the 2006 Military Commissions Act, has revoked the right to challenge the confinement in court for a select group who had been designated illegal enemy combatants without being able to recourse to judicial process. In the United States, in response to the terrorist attacks, at the beginning it was based on an executive order. The legal proceedings were based on executive orders. The court said, no, you have to legislate congressional legislation, so the Congress legislated the law. However, we see in a number of cases like Hamdi versus Rumsfeld and the Hamdan case, and finally the case of Boumediene. The case of Boumediene decided that people that are detained in Guantanamo Bay are entitled to judicial review in the United States. So this was a total change of the judicial policy. In Canada, the Supreme Court of Canada struck down an anti-terror law which allowed detaining foreign suspects indefinitely without trial or filing charges on the basis of secret evidence, while orders to deport them were reviewed. This is the case of Charkawi versus Canada Citizenship and Immigration. This was a case from 2007. In later years, it is to be mentioned that the case of Khader, where a minor of Canadian citizenship was arrested in Afghanistan and held in Guantanamo, the court decided to quash any admission, any confession that he made, because it was under torture. In the United Kingdom, I would like to mention that the administrative matter was discussed clearly in the UK, the question of detention, and others against Secretary of State of Home Department regarding the detention under Anti-Terrorism Act, Crime Security Act of 2001 of foreign nationals who had been certified by the Secretary of State as suspected international terrorists and who could not be deported without breaching Article 3. They were denied without charge or trial in accordance with the derogation from Article 5.1 provided by the Human Rights Act of 1998. And this is one case. And the other case which the court intervened was Bin Muhammad, where the court ordered disclosure of evidence that was given by the U.S. intelligence to the British Security Service. So in this case, the court did not accept the position of the Secretary of State in the UK. We see here a very clear activist approach. The Israeli courts have always been very active in terms of the review of judicial review of executive actions, including administrative detention, including the borders of the wall of security or the barrier of security. For the Israeli court, it is a matter of routine to deal with such questions, including target killing, unlawful investigative methods, and the limits for investigations. The two other examples I want to mention is the case of the German Constitutional Court ruling in 2006 that the statute authorizing the shooting down of a hijacked plane is unconstitutional. The reason being that the right to life under the Constitution, it's called Basic Law, Grundgesetz of Germany, cannot be subjected to any qualification. The argument was that the government cannot turn the passengers and the crew on the hijacked plane into objects, and the government cannot make any balancing between the right to life of the people on the plane and the right to life that have to be protected of the people that are going to be killed if the plane is used as a missile. So this does not solve the issue. What happens without an act? Could the Minister of Defense order the destruction of the hijacked plane and then still claim the ground of defense of justification on necessity? So the fact that you don't have a prior authorization does not mean that you don't have a post facto defense which will be based on necessity. And in fact, the Minister of Defense, after the judgment of the Constitutional Court, said, okay, that you decided so, but I will do exactly what I will have to do in case there is a hijacked plane. Similar decision was given by the Polish Constitutional Tribunal, 2008, more or less making the same reasoning of the Constitutional German Court. So here, to summarize, we see a very clear approach of the judiciary to subject both legislative measures and executive measures of emergency to judicial review, and we have to expect the courts to strike a balance. On the other hand, we have to expect the courts that the balance would be reasonable and not lean either direction, not to support invasive policies, however, to protect the public from very vicious and very damaging international terror organizations that pose a threat to democracy, don't respect life, use children as human bombs, and therefore the challenge of the judiciary is great, but having such great judges in India and other places, we have full confidence that they will give the right answer. Thank you.
What I was going to say in those circumstances, and along the theme that Professor Shatrit has been speaking on, the issue that I've come to speak about is whether the balance as between terrorism and human rights has been struck in the United Kingdom. The first piece of major terrorist legislation to be passed was the Terrorism Act 2000, Section 1, which defined terrorism as any political, religious, racial or ideological cause designed to influence the government of any country or international organisation or to intimidate any member of the public anywhere in the world. This clearly encompasses much more than the 9/11 or 7/7 situations, and there can be no doubt that the British courts have had great difficulty in grappling between the appalling consequences of terrorist activity and striking the balance in favour of much cherished principles of human rights. And in this context, on the 13th of July of this year, the brand new Home Secretary, the Right Honourable Theresa May, promised a review of counter-terrorism legislation in the face of a clear divide inherent within the government, being a coalition government, and much dispute amongst them as to the justification for this review. And very quickly, let me tell you what the 4 areas of intended review are. Firstly, stop and search powers. Under Section 44 of the Terrorism Act, legislation at the moment allows for the search of any person for articles of a kind which could be used in connection with terrorism. There is no requirement of reasonable suspicion the only requirement upon a police officer is if he or she is of the view that it's expedient for the prevention of terrorism acts. The impact on human rights in this respect means that essentially within the whole area of Greater London, a person can be stopped and searched at the whim of a police officer. The evidence shows that ethnic minorities have been overriding victims, with 17.7% of the people stopped and searched under the provision being Asian, as against 4% of the population. Recent authorities have clamped down on these provisions, and I'm using the shorthand for time purposes, of course, and held that Section 44 amounts to a real curb on the rights of the individual, and that as a result the government have undertaken to review the stop and search power as a matter of urgency. Secondly, 28-day pre-charge detention is currently permissible in the United Kingdom. This is a period which grossly outweighs the period of justified and legal pre-charge detention in any other jurisdiction in the world, as I understand it, and certainly in the free world. The evidence suggests that at least half of those detained for up to the 28-day period since 2006 have been released without charge whatsoever. And again, there is a divide within the coalition government as to whether this period should be reduced to the normal period of 48 hours or down to 14 days. At the moment, the power remains in force, but is up for review. Control orders have been particularly controversial. These permit for control orders to be imposed upon individuals suspected of terrorist activities, which allow for electronically monitored curfews of up to 16 hours a day, reporting requirements, bans on visitors, bans on certain communications and internet use, no passport, no travel documents, no driving licence, no MOT certificate, no camera, no mobile, no USB stick, memory card, anything of the kind, in circumstances where the individuals concerned have not been charged with any offence whatsoever, nor where there is any prospect of prosecution imminent, but simply where the Home Secretary takes the view that there is reasonable suspicion on the basis of evidence which cannot properly be disclosed that the individual is suspected of terrorist activity. The courts have recently ruled in a number of cases that control orders are contrary to the human rights provisions, and at the very least that evidence justifying them must be disclosed. And this provision, once again, has caused major dissent within government power, but is the third of four terrorist provisions said to be up for review. Finally, deportation with assurances, which allows for the practice of returning individuals who are deemed to present a risk to national security to their home countries, in circumstances where, as the evidence suggests, is still happening, torture and fundamental breach of human rights is at risk. Notwithstanding that the government stepped up its efforts recently to seek diplomatic assurances or memorandums of understanding with countries with questionable human rights records, nevertheless provision allowing for the return of individuals to states suspected of human rights violation still exists. And again, the courts have recently ruled that this practice is in breach of human rights legislation, and that the argument often taken that to return to country A with a view to country A then sending the subject on to country B is not a sufficient or justified circumvention of the power, and this allegedly barbaric power is one that is the fourth of 7 provisions up for review, and all I have time to focus upon. And so finally, and in conclusion, hopefully having met my 7-minute deadline, obviously, once again, the question arises, has the balance been struck in favour has it come down fairly in favour of the one side or the other? Has it been struck at all? The clearest possible evidence is that the domestic courts in the United Kingdom, bolstered by decisions of the European Court, take the view that this is not the case, and appreciating the difficulties that arise, of course, and that is an understatement, nevertheless, that substantial aspects of UK legislation are contrary to human rights provisions. At the moment, the much-promised review, which is now becoming something of an ageing process, has not begun. Whether it ever materialises or not, we shall have to wait and see. Thank you very much.
With the permission of Honourable Dr. Justice K.G. Balakrishnan, Chairman, National Commission of India and former Chief Justice of India, my respects to Professor Shimon Sharet, Mr. John F. Fernandez and Mr. Jaren Dean, the barrister from UK, and the esteemed legal professionals present here. A very good afternoon to all of you. Today it has been a very historic day for our country, with having a meet of the lawyers, the members of the jury from all over the globe. Well, the topic human rights and terrorism, as discussed by the eminent dignitaries sitting on the dais, and of course the respected senior members of the legal fraternity sitting in the hall. Human rights, as we all understand today, is a topic and a universal entitlement necessitating its fullest implementation. The Declaration of Human Rights in the original declaration, as well as in the Constitution and the laws of the countries, is a very big necessity today. As human rights awareness and countries is a very sensitive, has grown into leaps and bounds in today's time. However, the problems of implementation and translating them into practice exist, in fact, around the world in different manners. Violation of human rights are steadily on the increase on an unprecedented scale. Even in democratic countries like today in India, all have mentioned, we are witnessing the ongoing scenes of the terror attacks. So today, basically to start over with my topic, human rights coexists with the human dignity and the sovereignty of the human entity. All our efforts naturally have to bring to place today within the law, within the jury, within the court, that how to curtail this upcoming terrorism within the globe. Maybe it's our country, or maybe it's a neighboring country, or it's around anywhere. The sole purpose, as today we know that the National Human Rights Commission Act has been formed. It's an placement, like in section 3 of the Act, lays down the central government to constitute a body of the National Human Rights Commission, which is governed by a former Chief Justice of the country. But these commissions today, as we have all noticed, that if somebody becomes a witness, either he's a professional or he's a layman on the street, the commission needs to review certain amendments so that a common man who is affected, because an affected person knows what has happened. I would like to contradict a little thing that the media has exposed us a lot of initials, as a barrister colleague from UK mentioned, that also needs to curtail over aspects. Like today, the basic furnish of such information within the review of section 176 and 177 of the Indian Penal Code are the dire need by the Commission. Hence, the prosecution in the terrorism cases, in the terrorist cases, need an instant relief. Like the human rights, I take into prolong the theory of Ram Rajya is an ideal theory where there was a law and the human rights were available to all. It was in fact to all, as laid in that. Human beings were treated without discrimination in all affairs of the society, and there was no explanation of any member of the society. But today, we desegregate certain things. As we all understand, today we need to give a stress on the basic, all human beings are born free in the equality and the dignity of rights within the respective countries. They are endowed with a reason to conscience and should act towards one another in the spirit of brotherhood. Like in Article 1 of the Universal Declaration of the Human Rights, drafted in 1948, human rights, as mentioned, such rights which are vested in human beings, which are universal and inviolable. Given the choice, people today need the right thinking in the right direction, seeking cooperation from the society, adoption and appropriate policies which the government needs to amend in the legislation, in the laws, in the functioning of the courts. Such remedial policies should be adopted so that different countries or our country does not lag behind today in this aspect. I'll segregate into short as being conveyed by, for the precise time of 7 minutes. Like terrorism is an criminal act that influences an audience beyond the immediate victim. For example, in 1972, leave aside the present scenario of the terrorist attack. Such a disaster happened in 1972, which I'd like to quote before the esteemed members sitting here. That is the Munich Olympics. The Black September organization killed 11 Israelis. The Israelis were immediate victims, but the true target was later estimated that 1 billion people watching the televised event. The Black September organization used the highly visibility of the Olympics to publicize its views on the plight of the Palestinian refugees. It is not now. Later on, the immediate victims were about 240 US military personnel who were killed and over 100 were wounded. The target was the American people and the US Congress. Now the primary objectives, at my conclusion of this brief topic, the primary objectives of the effective counter-terrorism effort are to safeguard the human rights, strengthening the policies, the social laws, the economic laws, and above all, the condition, upbringing, and the progressive of the country. Thus, it is critical to strike a just balance between the ensuring the security and the integrity of the country, but safeguarding of the human rights is a necessity of the legal fraternity, of the jury, precisely to come up in a form of bar and bench today. Human rights violation by the states, its agencies occur in various settings during the cordon of such operations. In every operations today, the social and the legislative bylaws and the universal human rights articles need to be amended, and such all at a time. It is imperative to take a relook at the judicial process. To my concluding lines, with the permission of the Honorable Chairman, at the time it is imperative to take a relook at the judicial process to prosecute those accused by being involved in terrorist activities. They need to be having an instant evidence, instant trial, and placed under the stringent punishment, as we have witnessed in 9/11 or in the disaster over the terror attacks and in the Mumbai attacks. Speedy trial is an important objective to achieve to assure the guilty are punished on spot and the innocent are not always awaiting justice. Thank you very much for your patience hearing.
Dignitaries of the dais and ladies and gentlemen, it gives me great pleasure in presenting a paper on the subject Human Rights and Terrorism before this prestigious congregation organized by the International Council of Jurists. The object Human Rights and Terrorism is the present burning global problem with which every human being in all the countries throughout the world, the richest to the poorest, is horrified and worried about, and all the precious human rights of all human beings in the entire world, in all the countries, are at stake at the hands of the terrorist groups working in almost all the countries and causing colossal damage to the lives and properties, and particularly the precious human rights. The entire world is looking forward at the International Council of Jurists to take up the cause seriously and suggest a practical solution for uniform application throughout the world to eradicate the terrorism and attack on human rights. I wholeheartedly assert that we, the members of the International Council of Jurists, in particular with the cooperation of National Human Rights Commission of India, all India Bar Association and the Indian Council of Jurists, should indulge in exhaustive deliberations, particularly in the first working session on the subject of human rights, and evolve solutions regarding immediate steps to be taken to eradicate the evil of terrorism by consistent pragmatic effort. The terrorism is causing damage to human rights, particularly to right of life, right to protect their properties, and above all, the peace. Nowadays, the acts of terror and violence are perpetrated through various methods to achieve their objective, to subvert the system. The origin of this terrorism can be traced to the origin of the human race itself. When in those days ago, when the human race was living just on the natural resources, terrorism has been used by some Muslim men who are forming themselves into small groups and occupy the thickly populated areas and taking the entire population in the said areas under their control. That's how it is started. If we look back, it can be recalled that UNO adopted the Declaration of Human Rights on 10th December 1948. The said declaration ensures to every human being in the world his birthright to live a life without any discrimination on the basis of caste, religion, or sex. So, as declaration adopted by the United Nations organization express that it is the birthright of every human being to enjoy the human rights. In the entire universe, one of the special species with life is human being, a unique being with unique powers created by the great architect of the universe called God. And in the beginning of the universe, when the human being has been created, inherently the human rights are conferred by the architect of the universe. Thus, the origin of the human rights in the entire world can be traced to the beginning of the universe itself. It is universally known that the great architect of the universe has provided the human beings the natural resources like unpolluted air, pure water, great air, the plants, the trees, fruits and creepers and beautiful flowers, the rivers and lakes full of pure water. All these resources put together are essential for comfortable living of every human being, and it is a birthright of every human being to enjoy the nature's gift without any hindrance or interference from any quarter. When we think terrorism in ultimate analysis is an attack on the human right and depriving the humanity the benefits of gifts of nature from the great architect of the universe. This is a new angle I am trying to throw for this congregation to consider and decide. Of course, the Magna Carta of England Charter issued in the year 1215 AD has been the first passed law in the Greater Charter of Liberties of England declared the human rights passed in 1297 still remains in the statute book of England. Now, a reference may be made to the great document in the entire world, namely the Constitution of India, 1950, which is in relation to the very large democracy in the entire world. The human rights being complex and unimaginable, some of them only could be expressly provided in this great document, namely Constitution of India. Now, coming to the reasons for this terrorism and how they are emanating. Almost all the countries in the world, families below the poverty line are plenty. The children from such families are always unhappy and dissatisfied, and they are not able to enjoy the comforts as other children. Such children of 10th age will be creating problems at home. Majority of the children are prone to be attracted by the camps maintained by the terrorist groups with a hope that their unfulfilled desires will be satisfied at the end by promises and luring to the terrorists. In such camps, these children will be given good treatment in food, clothing, games and sports, and at the same time training them up forming war groups. By an analysis of this, the root cause is dissatisfaction of children from the families below the poverty line. It is a duty of the state to investigate and find out the root cause and try to eradicate them. One solution to the problems appears to be that the state should take the children of tender ages from the families below the poverty line and should give them the necessary education till they attain the age of learning. All such children should be properly groomed and their public energies are to be channelized to use the energies in constructive activities, as the youth of today are the leaders of tomorrow. Unless the youth are taken care of and they are prevented from indulging in destructive activities, the further of the country will be at peril. For the said purpose, a perfect legislation with stringent provisions is necessary. This International Conference of Jurists 2010, after deep deliberation, should evolve the format as the basis for great legislation to be adopted.
as there is a need to make a uniform legislation to control the funding of the terrorist groups in several ways. In this regard, the legislative, executive and judicial institutions must exercise their power and authority to protect the innocent citizens from fears and prejudices, and they should meet the challenge of terrorism with innovative ideas and approaches. The learned jurists, as a class known to be intelligent in the society, will have to suggest the strong and positive efforts to put forth the institutions, legislative, executive and judiciary. This problem has to be studied at depth, taking into consideration the activities and the attacks of the terrorists, and suggest the making of perfect legislation and evolve the schemes to be adopted by the persons and institutions charged with high power. It is also desirable to provide through such legislation a terrorist preventive force. A terrorist preventive force is to be created, specially designed and trained in the task of curbing the initiation of terrorist attitudes in the school children and even the college students. Apart from this preventive measure, a different force is to be put in action to carry on the combing activities to identify the places and groups indulging in carrying on training activities and also terrorist action in planning and attempting to the terrorist. A separate wing has to be developed as intelligence wing to investigate into the possibilities of developing the terrorist activities at certain places with certain individuals involving, so that preventive action may be taken for sweeping out these terrorist outfits. Another positive desirable activity is to be carried out to identify the individuals either having terrorist views and those getting trained in terrorist camps, and those who are indulging in terrorist activities, bring them out from the clutches of the training groups. There is another aspect which requires serious attention. In recent times, they have come to light that neighboring countries are indulging in encouraging the terrorist attacks into the adjacent countries. It has also come to light that the government of said countries are aiding and funding such agencies. The encouragement and cooperation in such countries must be detected, and the facts and figures must be put before the Security Council of the United Nations to take stern action. It may be recalled that about 30 years ago, the General Assembly of United Nations adopted a resolution of terrorism to unequivocally condemn all acts of international terrorism which endanger or take human lives or jeopardize fundamental freedom. In the same year, the General Assembly adopted a cancelled international convention against the taking of hostages. By 1991, 9 conventions have been held to deal with such aspects of terrorism. In 1994, the General Assembly of the United Nations adopted without vote the Declaration on Measures to Eliminate International Terrorism. In the year 2001, after the attacks on the World Trade Center in Pentagon, the Security Council adopted a resolution on 12 September 2001 which stated the preamble in a general way that terrorist acts cause threats to international peace and security. Now, conclusion, the need of the day now is global awakening about human rights and the threat that terrorism has posed to human rights of the people.
I call Mr. Parmarthi Venkatraman, Advocate of Supreme Court.
Chief Justice and Chairman National Commission, Human Commission of India, distinguished speakers, friends, ladies and gentlemen. I have 3 propositions to make for us to deliberate as jurists today and this very important conference, which is an annual exercise being undertaken by our good friend Dr. Adish Aggarwala and all the other good friends who are concerned for the state of society, the state of rule of law prevailing in our country as elsewhere. The first proposition is, yes, it is true, all speeches aside, the United Nations Declaration of 1948 aside, we all know terrorism is in our backyard. But if terrorism is in the backyard, human rights are the forefront. That is the first proposition we should always remember. Human rights are the forefront if terrorism is in the backyard. Secondly, should a democratic nation indulge in counter-terrorism to counter terrorism? This is another important aspect we as jurists have to address and try to evolve solutions rather than undertake post-mortem discussions or analysis of judgments or executive orders or judicial pronouncements. The third thing I would say is, what is the role of the mass media to create an aura of terror among many people? What is their role? because I was in London a couple of weeks ago. I noticed it is the same announcement there. I was in some other airport in some other country elsewhere, and it is the same announcement. If we go to the New Delhi International Airport, or you go to a railway station in any of the districts of this country, or you go to a bus station, you find the same announcement, albeit in different languages. Please beware of suspicious objects and people with suspicious behavior. Are we spreading panic like George Orwell in 1984 spoke of a big brother? Or are we speaking again of, like George Orwell said, all men are equal but some men are more equal than others? What exactly is wrong with humanity? Man is born free. We all know we all have equal rights. Yet we all know there are certain people who are oppressed, suppressed, depressed, weaker sections, refugees. We also have die-hard patriots, we have eminent jurists, we have men of wisdom, and we do not lack enforcement agencies in the wisdom of judiciary. So, this apart, what is important for us is to understand that even before the 1948 Universal Declaration of Human Rights, there was a universal attempt to try to bring about international amity way back in 1648, which is called the Treaty of Westphalia, which in fact is the foundation of all international law. As we understand, we come back to our own constitution. We have the preamble to the constitution, which speaks of an economic justice, a political justice, and social justice. So these are the factors which divide a human being or a race, or divide different classes or sections of the society. We must address our problems. We must address our situations. We must address all actions, be the executive, legislature, or judiciary, only to try to alleviate and bridge the gaps or perceived gaps which convert certain human beings into so-called terrorists, who again are not fanatic, religious, conservative people who perpetrate violence. In fact, the most devout fanatic people of all religions abhor violence. It is only the interpreters, the misguided, wicked elements, who do not speak of justiciable rights, who do not speak of conscionable actions, who do not know of reprehensible policies, who have got poisonous streams of thought, who try to inculcate and inject fear, the element of fear, into the human mind or into our system. So it is for us to understand how to inculcate strength of character, morality, ethics, not only in evolving good rules of law, but also in trying to understand how to do away with dangerous phenomena like bioterrorism, cyber terrorism, eco-terrorism.
matter of human rights. United Nations Global Counterterrorism Strategy gives importance of assisting victims of terrorism and providing them and their families with support to cope with their loss and their grief, and decided to promote international solidarity in support of victims and foster the involvement of civil society in a global campaign against terrorism and for its contamination. Consideration must be given to the distinction between victims of crime on the one hand and victims of human rights violation on the other. In most cases, terrorism-related acts will be treated as criminal offense, just criminal offences committed by individuals, and the state will not be responsible for the illegal acts done. Acts constituting human rights violations are committed primarily by organizations or persons. However, the state may be responsible for the acts of private individuals that may constitute violation of international human rights. Since the terrorists are, I'm just concluding as per the request, the terrorists are adopting sophisticated technological means for their attack, as you know. So, we cannot live in a society where every moment you have to watch around and suspect a human being who comes beside you. The only thing we have to do is be vigilant and share your observations with your fellow beings, not to harm anybody, but to protect and safeguard thousands of innocent souls who wish to lead a peaceful life. So let the concept of human rights begin from here. Let us forget the very word terrorism and pray for its vanish. So thank you very much for patiently hearing me.
Everybody who is in the hall, I'll thank everybody who is in the hall for cooperating and giving the time. So kindly go to the lunch which is in the hall downstairs. I will be pleased to welcome everybody who is seated in this hall. Well, we are waiting Honorable Justice Mr. Sirlik Joseph, Judge of Supreme Court of India, will be here within few minutes. I like to ask Mr. H.S. Hooda, the Advocate General of Haryana, to come up to the stage and start the conference. Asad Malik, Assistant Professor, Faculty of Law, Jama Millia Islamia, he is also there with us. I'll ask Mr. H.S. Hooda to give his views on relationship between judiciary, legislation and executive. Kindly give a big hand to him.
Jurists of the dais and of the dais. I will confine myself regarding the relationship between judiciary, executive and legislature as the topic of today before the distinguished guest. It is a great honor for me to be invited to address such an august audience from a topic of utmost public importance. Paying for the last more than 4 decades, a debate has been going on regarding relations between legislature, judiciary and executive, the 3 organs of the state. Under the Indian Constitution, all the 3 organs of the state have been given independent domains to exercise their powers as they may say under the Constitution, which provides a mechanism of checks and balances interchange. No authority under the Indian Constitution enjoys absolute power. The concept of absolute power is against the spirit of Indian Constitution. The legislature has the power to enact laws, whereas the judiciary is to interpret the law, and the executive's domain is that of the implementation of the law. Since all the 3 organs are deriving their powers and functions from the common source, that is the Constitution, they are as such under constitutional obligation not to transgress their powers or to usurp the powers of the other organs. In fact, this is expected from all the 3 organs to impose on themselves a self-respect. The legislature has premised for the domain of making laws. However, while doing so, it cannot violate the provisions of the Constitution or alter the basic text of the Constitution. Similarly, judiciary is supreme regarding interpretation of the law, but has not been provided the power under the Constitution to enact the law except in certain situations where law has not been laid down by the legislature. Then to meet such a vacuum, It may issue guidelines till the appropriate statute is framed by the legislature. Ours are the system of constitutional supervision. The Constitution is the supreme source of all governmental powers. The Honorable Apex Court, in a famous case, Goloknath, report in 1967 Supreme Court, observed as, I quote, no authority created under the Constitution is supreme. The Constitution is so supreme, and all the authorities function under the supreme law of the land. Unquote. This principle has been reiterated in several cases since then. In a democratic setup like ours, the main aim of all the three organs is to work harmoniously for the welfare of the people, to achieve the aims and objectives and safe in the framework of the Constitution, the five feet of the framework of the Constitution. The principle of separation of powers is not adhesive. In Act of 1951, in the first presidential reference, AR reported as AIR 1951, page 332, the Apex Court clarified that the principle of separation of powers under our Constitution is flexible, unlike other constitutions such as that of the United States. In the recent past, it has been debated that the judiciary exercising the powers beyond its subject assigned to it under the Constitution. Sometimes it is said it is the judiciary or judiciary's origin, the other organs of the state. However, if it is examined in a slightly dispassionate manner and in depth, the view of this school of thought may not stand because of the reason that the Honorable Apex Court has laid down certain guidelines or principle of justice while interpreting Article 21 of the Constitution of India. To interpret the law is in fact the domain of the judiciary. It is amply clear that Article 32 and 226 of the Constitution confers on the Apex Court and the High Court, respectively, the power to issue various writs, directions or orders. Under Article 32 of the fundamental right itself, which means that the Honorable Apex Court is under constitutional obligation to correct, enforce and implement the fundamental rights, and the Apex Court is not merely empowered to do so. Therefore, not only does the superior judiciary have the power to declare a law unconstitutional or void, or for contravening any provisions of the Constitution, rather it must ensure that fundamental rights are enforced in their due strict. There is no dispute that judiciary has the power to interpret the law under the Indian Constitution, but in the sense of law framed by the legislature, the judiciary has the jurisdiction to legislate, to fill in the vacuum in the interest of justice. For instance, there was no law pertaining to inter-country adoption. In order to prescribe some norms relating to this, the Lakshmikant Pandit was the Union of India, which is reported as 1984 SC 46. The Apex Court stepped in and laid down certain guidelines and procedures for the safeguard the interest of minor children relating to inter-country adoption. Similarly, legislative vacuum was also covered by the Honorable Apex Court in a famous case, in a recent famous case, Vishakha, the state of Rajasthan, reported as 1997 Supreme Court 3011, by laying down the guidelines regarding the protection of the women at the workplace. In other words, while laying down such guidelines, enacting law, it does not mean that the judiciary overreaching or usurping the functions exercisable by other organs of the state. Rather, it is merely filling in the gaps and not preventing the legislature to enact law to meet such situations. In fact, the Protection of Women Against Sexual Harassment and Workplace Bill 2010 was introduced in the Lok Sabha about 3 days back, thereby further showing that the guidelines laid down in the aforesaid judgment in of Visakha, but the state of Haryana, did not preclude the legislators from enacting the statute in any manner. The view of the school of thought characterizing the approach of the judiciary as being only appears to be based on the fact that the judiciary cannot exercise such lawmaking functions because it is a political organ and the Constitution even says all lawmaking to be a result of political debate and of dialogue. This view, however, can be addressed by stating that the tremendous public confidence reposed in the judiciary today itself is due to the fact that it is apolitical. The success of the judiciary in India is a result of this public trust and the confidence reposed in a political process of often highlight differences with those differences in ethnicity, caste, religion, culture, or linguistics. The judicial process seeks to bring all these and places the meaning of Indianness on the top. The judiciary helps the nation move forward. It does not only, but really essentially. Thank you very much.
Thank you, Mr. Rota. Well, now I call upon Justice Riznik R. Nizamanda, High Court of Malawi.
Greetings, Zik Amanda. I'm a judge at the High Court from the Republic of Malawi. Malawi is a small country in the southern part of Africa, close to Mozambique, Tanzania, and Zambia. You can also think about South Africa. That's where I come from. And Malawi's legal system is pretty much like the Indian legal system. But I must say that India is renowned for being the largest democracy in the world. First of all, let me thank the organizers for giving me this opportunity to come here and share some few thoughts with colleagues and perhaps learn a few things as well. Like I said, Malawi is a democracy. It's a new democracy, as it were. It only became a democratic state in 1994. Before that, it was a dictatorship. Now, when we talk about the relationship among the judiciary, legislature, and the executive, we are really talking about, well, it only becomes relevant when we are not in a dictatorship. The talk about the relationship only becomes relevant when we are not in an authoritarian regime or an autocracy, or indeed where no tyranny reigns in the running of the affairs of the state. We talk about constitutional democracy with three separate arms of government, being the judiciary, the executive, and the legislature. When we talk about democracy, we talk about democracy not as an idealistic or abstract concept, but we are talking about the real driving force towards progressive well-being of individuals and societies. So when we think about democracy, we should not think about it as an abstract concept, but something that is going to make our society better. And democracy is not as a tyranny of the majority, because the majority can also be tyrannical. The rule of the majority can be taken too far, such that you trample over the rights of the minority. So democracy must not be thought of in terms of the majority, the tyranny of the majority. This is a democracy where both the rights of the majority and the minority are respected. And that's where you're talking about the relationship amongst these three arms of government or state. Constitutional democracy as a foundation of good relationship among the judiciary, legislature, and executive means that the Constitution properly provides for the separate status, function, and responsibilities of the three arms of government, or three arms of state. Of course, we know of different types of democracies: majoritarian democracy, pluralistic democracy, elitist democracy, constitutional democracy. I don't need to define all those. I think that the people here are were familiar with all these. But the idea of separation of powers began many years ago. It began with John Harris, if you remember, 1656. And then, of course, in 1690, John Locke, the English legal philosopher who idealized the idea of separation of powers. And then came to, in 1748, Montesquieu, who kind of refined that idea of separation of powers. The idea was that power should not be concentrated in one person or one individual or one body, but rather it should be spread out if it's going to work for the better of all the people. But why should we talk about the relationship among these three arms of government when we know that the Constitution clearly separates their powers? Why should we talk about the relationship? Why is it necessary to talk about the relationship? It is important to realize that constitutions do not spell out in detail how these three arms of state will exercise their powers. And so there is room for informal rules being applied in order to ensure that the machinery of government works. And it is where these informal rules come in that we begin to see problems of the relationship amongst these three arms of government. Why? First of all, because there's mutual suspicion of intentions and operations of the other branches of government. The judiciary will suspect that the executive will do something else, and the judiciary will suspect that the legislature is going to do something else. Similarly, the executive will do the same thing. The executive will also do the same thing. The second reason is failure to distinguish between what amounts to checks and balances under the Constitution as properly provided and what is unwarranted interference with institutional performance of each one of these arms of government. The third reason is competition of supremacy for each branch. Each branch would like to be supreme over the other, would like to show the muscle. And because of that competition, you have problems of relationship among these arms of government. The fourth reason is lack of appreciation of the constitutional, of what constitutional democracy means. That in constitutional democracy, it is the constitution that reigns supreme. You get rid of parliamentary supremacy, you also get rid of executive supremacy, you get rid of judicial supremacy. The fifth reason is obsession with power and a misapprehension of what that once one is elected into power, then one has got all the solutions to social problems. Once you have that misapprehension, that you know it all, then you're bound to initiate conflicts amongst the different arms of government. But is it possible to have a good relationship? Yes, it is. It is possible to have a good relationship amongst these three arms of government, despite the many difficulties that we tend to face. That is what modern constitutionalism is all about. It envisages a good working relationship amongst the three arms of government to ensure that they promote the personal or individual well-being or societal well-being progressively. And the rule of law also envisages that there should be respect for the rule of law, that everybody is subject to the rule of law, whether you are in the executive, in the judiciary, or in the legislature. You are all subject to the rule of law. And if we respect that, it is possible to have a good working relationship among the three arms of government. I'm told that I'm running out of time. Any desire for competition amongst the three arms of government should be gotten rid of. If you get rid of that, then you are going to ensure that you develop a good working relationship. Again, for purposes of progressive well-being of society. The three arms of government represent division of labor. They form specialized institutions which all contribute towards progressive well-being of society. How to achieve it also, you might wish to have heads of the executive, the legislature, and judiciary meet from time to time in order to them appreciate their different roles, and therefore what they understand about their roles will cascade down to the various people. The judiciary upholds the good relationship by using the power of judicial review. As was said earlier, the judiciary is given the power to interpret the laws, And it is only the judiciary that is given that authority to interpret the laws. By doing judicial review, it ensures that there is good working relationship. Again, the legislature should exercise its supervisory roles as is provided for under the Constitution. Apart from making laws, the legislature also supervises the workings of government. The different committees of the legislature help in supervising the workings of the executive. Again, the executive must know that the resources as approved by Parliament must be used for the purposes that are intended, and that must not overreach, must not deny the other arms of government the resources. Outside these three arms of government, you strengthen intra-party democracy. That is outside the three arms. Also, you strengthen civil society or non-state actors to ensure that the working relationship is good. You also improve literacy levels in the country so that people are not, illiteracy of people is not abused to the advantage of some strong and powerful people. And also, of course, reduce poverty, and that's something that we've been talking about. Well, my time is up. I think I've got to stop here, but I think this conference can also suggest how we can better improve the relationship that is always acrimonious amongst these three arms of government. Thank you very much.
I call upon Dr. P. Ratnaswamy, Senior Advocate, Supreme Court of India.
Esteemed delegates and practicing lawyers, ladies and gentlemen, I do not like to ponder over the technicalities of separation of power. Rather, I would like to place before you what could be the modus operandi, what could be the suggestive measures, so that we can strengthen separation of powers rather than making critical assessment and statements vociferously. We believe in democracy. Rather, I adhere to judicial democracy, not being simply belonging to that fraternity, but it has proved success in the glorious history of democratic world. The judiciary is not committed to individual serfdom. It doesn't belong to one man or a group of unorganized or unaware of consequences of their pronouncements. They belong to a sector. They know their responsibilities. They are aware of their judgments, pronouncements, what they are doing and for whom they are delivering the judgments, and they are to whom working for. But it's more important, there is a lacking of judicial accountability. Globally, all democratic countries, even dictatorship, they struggle hard to find solution to judicial accountability. Yet somewhere it is creating a nervous in the minds of fraternity of judiciary. The politicians, they like to have upper hand, criticizing the ferocities of some kind of upheavals in the judicial benches. Recently, Supreme Court has said, rotten High Court. It has its own purpose, meaning. It is not a criticism. It's sounding well what we are we doing the right thing? Do we lack anything how to overcome? Yesterday, in the media, a 30 years old boy, young boy, questioning left and right. I felt uncomfortable for one reason. Not aware of the strength and purpose behind the words rotten. Superfluously ordinary man, he thinks a different way. But fraternity from the legal world, he understands. It's only improvement. While in public interest litigation, so many cases are coming, particularly corrupt practices. For example, in Australia, in the case of Lewis Ross versus the Commonwealth, when we take a decision, when the Honorable High Court of Australia, the public doesn't appreciate, so they wish the judiciary must abdicate its responsibility. The criticism should not lead to the abdication. Similarly, in the UK, the Burma Oil case, where the judiciary tried to sound something is wrong, immediately they brought legislation to nullify the effect of it. Other more important, the Marbury versus Madison. I looked at this. Marshall is an opportunity of convenience. He had to bring the reconsideration of judicial review, judicial power, just to safeguard his appointment as a Chief Justice. That kind of convenience of opportunism, if it removed, the judicial accountability can be enforced upon. For that, I would like to suggest only one thing, a regular interaction between the executive and legislation. The judiciary bench, they can go and attend the seminar conferences presided over the Speaker of both the houses, and the Chief Justice can also be party to them. It is possible through the Select Committee of Law and Justice. We need not create a new enactment, new legislation to curb the independence of judiciary. The Parliament doesn't work or not, we are seeing pandemonium currently. The government has to work, the people have to live. Justice has to take place. The executive, with enormous powers, with a highly trained skill and technicalities knowing aware of it, they can twist the decision in favor of an individual or a group. So somebody has to build a cadre, only judiciary can. We have to strengthen independence of judiciary, not at the cost of Parliament or the executive. At the same time, we need not be necessarily going against the mainstream of the dynamism. The society is looking for development. If we are pulling back, that is what the biggest criticism against the judiciary is. The executive always make the statement, they don't understand. They don't have strong skills and caliber. They are not qualified to make judgment on very, very complicated issues on expenditure of sources, etc. It's only a matter of concern for everybody. At the same time, the last I like to make, the eradication of corruption. The eradication of poverty, the judiciary only has done it. Now, the time has come. All three limbs of the governance have to work together to eradicate corruption. The corruption takes in four forms. Induced corruption for particular group of individuals or a MNC or corporate sector, a community, a class, just to enrich their economic welfare or social status or political prosperity. They try to influence every arms of the power, governmental power, governance, by way of inducement. At the same time, the persons in the government power can also induce the person to fall prey to that inducement of corruption. That has to be curbed. Then inactive corruption. This very silent. If you walk down to the railway stations, साहब इनको 10 रुपये दिए तो बर्फ मिल जाएगा, 100 रुपये दिए तो बाबू कागज दिखाएगा. See, just it has become inactive because everywhere you go to the revenue authorities or any, even in the judgment copy to get, the babu demands something inactive corruption. This has to be corrected upon. Then irregular corruption, the recent Commonwealth episode, 2G, spectral, all these things are irregular. Occasionally it comes in a huge way. How to
The successful strengthened separation of powers can eradicate corruption. A strong parliament can only do it. A sound executive power can only do it. An independent judiciary can alone eradicate this corruption. This is the foremost issue before every country, particularly India. With that, I thank everybody, the organizers and the fellow participants. Thank you. Bye.
Now I call upon Dr. M. Asad Malik, Assistant Professor, Faculty of Law, Jamia Millia Islamia, to come up and give
And ladies and gentlemen, I will discuss on this relationship among judiciary, executive and legislature. Only 5 minutes has been allotted. It's very difficult. First of all, I would like, as the earlier speaker told, the doctrine of separation of power is an essential feature of all modern constitutions of the world. And this doctrine has been originated in England, but there is no separation of power because of the parliament sovereignty. Only constitution of the world, that is the America. There are 3 articles, first, second and third, talks about this separation. But ultimately, this is no rigid separation of power. Ultimately, the checks and balances has been followed in America also. So far as India is concerned, I will talk about this historical background. There is no need. Only Article 50 that partially talks about this. 3 cases decided earlier. As the sir told, in the Delhi Laws Act 1951, Ramdevaya Kapoor 1955, Ramkishan Dalmia Justice and Local 1959. All these 3 cases, the Supreme Court of India held that this is not a part of our constitution. Rigidity, there is no rigidity, but it is a separation in India. But Keshwananda Bharati and onwards, that is a basic structure of Constitution of India. But in present time, the question of this relationship, because it is to be said the one organ is encroaching the field of the other. It is based on the power corrupt and absolute power corrupt absolutely. Because of this reason, the all power should not be concentrated in one organ of the government. But here it is to be said in the name of the judicial activism, whether the judiciary is overreaching the field of the other, whether it is required or not. This, if we will see the provisions of the Constitution, there is a relationship because every organ works with the other. For example, Article 53 only talks about the executive power vested in the President of India. No other article of the Constitution talks about that legislative power vested with the Parliament or judicial power vested with the Supreme Court or High Court. Because the legislative power with the Parliament or state as Article 245 and legislative power in the Supreme Court or other powers can be delegated to the executive also, and judicial tribunals also working the judicial function. So it means there is no separation. The other are executive also performing judicial function, judiciary performing the executive function. It means there is something, or there is some overlapping here also. Recently I will discuss only the 3 cases and thereafter I will give my suggestion. As this G. Singh versus State of UP, 2007, 586, this Justice Markandeya Kadri in this case clearly held the judiciary should work within the self-restraint, judicial restraint. That should also be treated as judicial respect. Because if the judges work like a legislator, then the judges should be elected. Why they should be appointed? We don't have expertise. Recently, 2 days back, the High Court of Delhi gives the very good example when this High Court said that the NET and SLAT is the mandatory for the appointment of the lectureship because it is not our arena, it is the matter of the academician. There is no need to interfere. And thereafter I would like to mention here Aravali Golf Club case, State of Haryana, 2008. In this case also, this Supreme Court of India held that if there is balance has been disturbed, because if one organ will interfere with the other, then the balance will be disturbed. In this case also the court held that the main plea is that if the 2 organs of the government is not working well, because of this the judiciary is interfering. The judge said that the same question can be asked from the people or the organs, because if the judiciary is working well, why dependency is increasing day by day? So we have to work within the limits. And thereafter recently in 2010, University of Kerala versus Principal College, 2010, also the Supreme Court, Justice Markandeya Kadri held that the separation of power is the part of our constitution and the judiciary should also work within the self-restraint. But here the question is whether we are living in a largest democracy of the world, where the people participating in the election, casting their votes, electing their representative, having the some expectations from these organs. Particularly the executive and the legislature should fulfill these expectations known as the legitimate expectations of the people. If the prime organ of the government, legislature and the executive is not fulfilling these expectations, then the question is who will fulfill? Then it's the judiciary. Judiciary should come forward.
Particularly when these expectations of the people is not fulfilling well, then the judiciary should come forward. Why? Because in India the judge is treated second to God. The people having the more faith in judiciary, but unfortunately in present time, all the legitimate expectations of the people turned down in the name of the corruption everywhere prevails. Because in legislature, in executive, somehow as the question also raised about the judiciary. So first of all, it is necessary, as these are told, that the corruption should be eradicated, and these particular legitimate expectations of the people, those the people have, should be fulfilled. Thank you very much.
Honorable distinguished guests, Adish and friends. The principle of separation of power is based on the maxim absolute power corrects absolutely. This principle of separation of power has not been emphasized in clear terms in our constitution, but relates to mutual relationship among three main organs of the government, namely judiciary, legislature and executive. Apparently in broad sense, it seems prima facie that our constitution is based upon the doctrine of separation of power. Judiciary is independent in its spirit. Neither executive nor legislature can interfere in its activity. To strengthen this independence of judiciary, the constitution restricts the legislature from discussing the conduct of any judge in the parliament. The function of judiciary is not only to impart justice, but also to act as a watchdog. The Supreme Court or the High Court has the ample power to interpret the laws made by the legislature and declare any law as void if it is found to be unconstitutional. The legislature is empowered to legislate laws. The privileges and immunities granted to its members are immune from judicial scrutiny. The President is the executive head. All the executive functions are done in the name of the President or the Governor. The President or the Governor also enjoys immunity from civil and criminal liabilities. In this way, in broad sense, it seems that our Constitution is based on the doctrine of separation of power. But in a strict sense, this doctrine of separation of power has not been awarded a constitutional status. Generally, the legislative power has been entrusted to the legislature, but under some specified circumstances, the President is also empowered to exercise legislative functions by way of issuing ordinance and formulating laws while proclamation of emergency is in force. President also performs judicial functions. The executive powers vest in President, but in real sense, Prime Minister, along with his Council of Ministers, is the real head who is responsible and answerable to the Parliament. Similarly, Parliament, in matters of breach of its privileges and in case of impeachment of President or the judges of the Supreme Court or High Court, it exercises judicial functions. Similarly, judiciary exercises executive or administrative functions when it supervises the subordinate judiciary. It also exercises legislative functions when it formulates rules regulating their own procedure. In other words, our Constitution does not follow the principle of separation of power in absolute terms. Rather, it is based upon the principle of fusion of powers. In fact, we have adopted the principle of separation of functions and not of powers. The theory of separation of powers is not part and parcel of our Constitution, but even then, except where the Constitution has vested powers in a body, the principle that one organ should not perform functions essentially belongs to others is followed. British parliamentary system has a large impact on our parliamentary democracy, but the framers of our Constitution were intelligent enough, and thus the freedom of judiciary was taken from USA. In our Constitution, judiciary has been made free from biased influence of executive and legislature. To maintain the supremacy of the Constitution, the judiciary has been empowered with a strong date to act as a watchdog by declaring such act of either legislature or executive to be void or unconstitutional, which violates the fundamental principles of the Constitution. Any law which violates constitutional provisions can be invalidated by the Supreme Court or the High Court. The Supreme Court has a vital power of judicial review which cannot be taken away. In our democratic system, the interests of the people of India are paramount. It is inherent duty of all the three organs, judiciary, legislative and executive, to perform meaningful roles in making the life of the people better. Such meaningful acts could be performed only with healthy interrelationship between these organs. Effective, transparent and accountable governance governance requires that all the above three organs functions collectively towards the constitutional goal of ensuring that each citizen enjoys the fundamental rights available to him. The Supreme Court and High Court have been empowered to protect these fundamental rights. Whenever there is a constant failure of good governance at the hands of other organs, then it is a function of the court to check, balance and correct any failure. The function of the judiciary is to protect the rights of the people by limiting the government arbitrariness and abuse of power. The supremacy of the Constitution is preserved and protected by the judiciary. In past, the Supreme Court has declared the constitutional amendments ultra-vires when it found that it was against the spirit of the Constitution. It has restricted the amending powers of the Parliament to the effect that Parliament, by exercising the amending powers, it cannot touch the basic structure of the Constitution. In Keshwanand Bharti case, the Supreme Court gave its historic judgment and held that Parliament cannot change the basic structure of the Constitution. The judgment was criticized by saying that judiciary has crossed its limit. In past, there remained a constant tension between judiciary and legislature on so many issues. Sometimes it seems that judiciary has exceeded its limit by interfering with the policy decisions of the executive. Mr. Somnath Chatterjee took exceptional note of it in his statement during Dr. Kailashnath Memorial Lecture. He said, I quote, "The contention that judiciary should take on itself onerous responsibility of the governance of the country in matters which the Constitution has imposed on either the executive or legislature has serious implications." Unquote. Presently, when the corruption has become a common phenomenon in all the spheres of life, these three organs are also not untouched to this evil. As far as the conduct of members of Parliament is concerned, some of them were found to have taken bribe for raising questions in Parliament. Even when there is a coalition government, either in the centre or in the state, the members are given bribe to form the government. It shows that moral values in general have diminished. The highly praised public servants have been found corrupt. In such prevailing corrupt circumstances, the responsibility of the courts has increased. But recently the Supreme Court has made a remark on the functioning of Allahabad High Court, which has shaken the faith of the people. As evident from the past, there is a constant tension between judiciary and legislature, either on the question of creamy layers in reservation, or corruption issues, or judicial scrutiny of the decisions of the speakers of legislatures. The relationship between the legislature and judiciary has become tensed. To remove this tension, healthy relationship between these three organs is very much required. A close relationship between the judiciary and legislature, not in a manner of controlling each other, but of a mutually complementary relationship, is required, and except where the Constitution has vested power in a body, the principle that one organ should not perform functions essentially belongs to other is followed. Thank you very much.
Krishna, to come up the stage and give
everybody on the dais and off the dais. In fact, I was supposed to talk on the women empowerment aspect of the topic, but unfortunately I was not aware of the fact that this session got changed. So I felt, let me express myself on the relationship between the judiciary, legislative and the executive. Well, the distinguished speaker still now has spoken about the theoretical part of it, as far as what is the separation of powers, Montesquieu theory, the Supreme Court judgment, so on and so forth. But I would like to take a different viewpoint. I would like to take the role of a common man of the country. After all, the rule of law is for implementation. For whose benefit? It is for the common man's benefit. And what is the common man's perspective of the rule of law? Or what is the common man sees this relationship between the judiciary, executive and the legislature? We have been talking about in the press that it is fanciful to blame the judiciary for the pendency of cases. More than 2 crore cases are pending here, there, so on and so forth. It's a matter of fact. But however, we generally miss on a point that the disposal rate of cases in India are extraordinarily high when compared to the disposal rate in other countries. Why is this situation? The methodology adopted
the methodology adopted in the disposal of cases makes all the difference. Where it is not time bound. I can argue a case for hours together or days together if the judge is ready to hear me. But is it the case elsewhere? No. And once I file a case, the case is being, it takes its own sweet time before it reaches its final hearing. So these are all contributing factors to the delay in judiciary. But now, is the judiciary to be blamed for this? Absolutely not. The reason is, I am talking about the relationship between the judiciary, executive and the legislation. In the common man's perspective, when there are 2.5 crore cases are pending in India, it is a statistical data that around 60 to 70% of the cases, the government is a respondent of the cases. Why not the government file its counter immediately within 6 months as stipulated in the rules of writ rules? It won't. It won't. Then who is contributing to the delay in the justice delivery system? Is it not the executive? By not discharging their responsibility within proper time schedule. Are they contributing to the common man's benefit? No. Is an affirmative answer which I would like to place before this August forum. Then, if supposing the judiciary intervenes and passes an order, why the government should wait, the executive should wait till a contempt is also moved in the same court? And in the contempt proceedings, if I am not committing a contempt, act of contempt, I may be permitted to say that why the judiciary is not taking a serious note and why the contempt cases are closed, because they are implemented. The act of contempt was committed when the order was not implemented. That is all about it. But unfortunately, once the executive comes before the judiciary and says, we have implemented it, we close the contempt case. But are we not taking the teeth out of the Contempt of Court Act? Are we not supporting the delay process of the benefit to the common man? Because the constitution is given by the common man. Every citizen has given the constitution to ourselves. We have given constitution to ourselves. So it is my responsibility as a common man to question this. So this is one aspect of the pendency of the cases. And the next part of it is executive. At the drop of the hat, we have a new legislation. In my firm opinion that, though it is of 1872, the Indian Evidence Act is very well sufficient for today's requirement. The IPC is very well sufficient for various things. We don't require an act for throwing of acid, for throwing of ball, for throwing of a cricket bat, for throwing of something else. The existing laws are more than sufficient. Do we have a statistics of how many laws which are now in force in India? If any of either the executive or the judiciary or the legislative, I am afraid we may not get the data. If we try to get the information on the Right to Information Act, probably would not get the data immediately. When such is the status, can we expect that the common man is getting the benefit out of the separation of powers? I don't know whether I have taken a wrong stand, whether I am speaking the right thing or not from the present forum. But however, the relationship which we are talking about, yes, the judiciary has to deliver the legal decisions based on the material before it, and it is bound by the legislature. And why the legislature is enacting n number of acts day in and day out at the drop of the hat? And is the legislature doing? Is there any system where the education qualification is prescribed to become a member, to go into the legislature? No. When that is not the case, again, it is the executive, the bureaucrats would create the document, and that is being spelled out in an open forum, whether the law is made by the legislature or by the executive. A question mark again, it needs to be answered. So, the identity of legislature, the identity of executive, the identity of judiciary should be known to the common man. The common man sitting across any part of the country should feel that, yes, the legislature is for my benefit, the executive is for my benefit, the judiciary is for my benefit. But is the common man feeling so? No. Unless this situation comes, unless something is done with a cooperative attitude. Now, we can notice a situation where, as the learned speakers were talking for a moment a little earlier, that the executive finds fault with the judiciary that they do not know this. And the judiciary finds fault with the executive saying that they are not properly doing this. And the legislature finds fault with something else. Why is this fault-finding machinery taking place? Why not we act in coherence? Why not we act hand in hand and see that the common man gets the actual benefit for which they were made to sit in their respective positions? This is all a pointer I wanted to place before my friends. I did it. If I made a point, kindly continue the thought. If not, excuse me. Thank you.
To the speakers who were giving their thoughts, very thought-provoking matters. I especially mention about the last speaker. He repeatedly used the term common man. I think all the problems in this particular country lies with the use of that particular term common man. That has been hammered down in our brain. We never think that a man is not a common man. He is the master of this land. That thing we have always said. All the legal luminaries are here. I should remind you that what the power has been given to that particular common man. Who is that common man? He is a citizen. You know what power a citizen enjoys? There is a judgment given by US Supreme Court that it is not our function, it is not the function of our government to keep the citizen from falling into error. It is the function of the citizen to keep the government from falling into error. This particular judgment has also been referred by the Supreme Court of India. Now, this shows where the citizen's power lies. In fact, in a democracy, power lies with the citizen, and no power lies neither with judiciary, nor with executive, nor with legislature. What they are enjoying is only responsibilities given to them by those common men actually who are citizens. We have forgotten about this. And why and how? There I am just giving you an example, and I am just sharing my thought. This is because everything lies with the problem of law in this country. And the supreme law of the land is the Constitution of India. That we know. But did you ever think whether this Constitution of India, which we call the supreme law of the land, it has a legal standing? I am questioning that legal standing in good faith. I am a citizen of India. I have full allegiance with the Constitution. That's why I am a citizen. Now I am thinking as a person from academic angle. Whether the Constitution, now I am thinking as a person from academic angle. Whether the Constitution of India, it has a legal standing as a supreme law of the land. Why I am saying? Let's go a little behind when India was under British rule. In the year 1947, we say that on 15th August 1947, India became an independent country. But sir and madam, let me ask you one simple question. What really happened on 15th August 1947? That particular day, a new act made by the British Parliament called Indian Independence Act 1947 came into operation in this country. What did it say? That on that particular day, the territory of India shall be divided into two dominions, two independent dominions. One, India, another, Pakistan. Now that India was not an independent country. That act did not make any independent country. That act made only an independent dominion called India. And that act also provided that there shall be a constituent assembly which are already set up by the British government itself to frame a constitution for that dominion, not for that country, dominion. And till the new constitution is adopted, the law of this land to be continued as Government of India Act 1935. And the person who is responsible to look after everything was Governor General, who was appointed by the British King. So till 26 January 1950, when the Constitution was adopted, India was 100% a British dominion. Therefore, if we say that 15th August 1947 is the Independence Day of our country, I think we are making mistakes. Now the question is, if India was totally ruled by the British law till 1950, 26 January, then up to that time, that point of time, the people living in this country were all British subjects, and the Constituent Assembly, the honorable members of the Constituent Assembly, they were also British subjects. The act which they made, which we call Constitution of India, was definitely a British act. Citizens of India, that is the reason why, if we say that Government of India Act 1935 was continuing, then Constitution of India was a British Act. If it was a British Act, then it was made by the British subjects. But we, the Indian citizens, why should we accept, or why we were imposed upon an act which was made by British? Now that constitution was specially devised by them in such a manner that the judiciary, legislature and the executives, they function in harmony to continue their own interest. Maybe this is the reason why we are still suffering, because we as Indian citizens, we have no power to make our own constitution by virtue of the fact that Indian constitution cannot be amended to the extent that it takes away or it interferes with the fundamental or the basic features of the constitution. Now if that be the case, then in our country, we the citizens of India will never be able to make our own laws. Thank you very much.
Again, we should discuss judiciary power.
About the fact.
Kindly address your question to somebody.
Yes, I am addressing to those who have taken the name of Allahabad High Court, which has been said as a rotten High Court. I want to place only 3 facts. The single judge, Allahabad High Court has been. Will you please hear? Allahabad High Court has the distinction of unseating Prime Minister. It has the distinction of unseating its own Chief Justice by judicial verdict. And then in this very case, single judge had passed some order, interim order, which was set aside by the letter of patent appeal, and 1 lakh rupee fine was imposed. Now the person petitioner had come. The error was committed by single judge that was already undone by the division bench. Therefore, there was no occasion to condemn the Allahabad High Court. And in that case, neither son was appearing nor father was appearing. So it was wholly uncalled for. And this is Allahabad High Court is the largest. In fact, during the days of emergency, it has given the celebrate judgment also. So I suppose I strongly express my reservation about this comment, especially here.
Okay, that's all right, but should I ask one question that why don't you comment on what is presently happening in Allahabad High Court? We belong to UP, we know what is happening.
Yes, with respect.
Yes. If you want to comment it, I can.
Yes, I'll put.
Not in gentlemen. Request of the members and fine. Let's have some discussion on the subject. Thank you.
Yes. Actually, the questions regarding the separation of powers between the 3 pillars of the Constitution, that is legislative, executive and the judiciary, it is all boils out of the self-disciplining and the credibility and integrity of the individuals. If everybody restrict to their powers enshrined on the Constitution, there would have been no problems. It is only because each and every organ of the state are trying to create. So my suggestion is that what about if we can restrict ourselves after that post-retirement benefits given and the lucrative attitude of the peoples who are retiring from the post, either from the legislative or from the executive, like the bureaucracy, or from the judiciary. If that can be seized, I think this will give the best answer to everything. And this is my suggestion that we can. No, my only suggestion.
My question is that in lifeline of every country, there comes time which requires radical reforms in view of situations which are radical themselves. don't you think this idea of separation of powers would be the biggest barricade if a situation like that comes in the future when we need radical reforms and with immediate effect?
Separation of powers, the purpose of the separation of powers in 1787, John Adams, when he was moving this resolution, with the Philadelphia Convention, he made the point, separation of powers is not to enrich or expand, but remove any absolute power exercising by any one of the organs of the government. The very purpose is to exclude dominance. It's not meant for pro-growth, pro-development. Over a period of time, the benefit goes to the judicial activism and judiciary and the legislature and executive. All they jointly work together to promote the humanity. Converted into welfare state, they try to work together. Marginally there is overlapping. That marginal overlapping at times, that is the tension, that is Lord Wolf in the High Court of Australia when he was making the pronouncement. The separation power is consistently creating tension among these three arms of governance. It's wantonly made this separation of power. Thank you.
Sir, but if we need radical reforms, there won't be one organization which two people could go, because, for example, if we want reforms in our constitution, the very judiciary can announce any kind of legislation by saying that it is not.
Sir, I would like to just highlight one point, as you are suggesting. In fact, this aspect has been dealt with by the Honorable Appellate Court in a number of cases. And now, except that the Indian legislature cannot alter the basic structure of the constitution, all other parliament or the state legislature. So, one thing I would like to say before this August House for the consideration, Indian judiciary has played a significant role in strengthening the Election Commission of India's power, where the entire world is looking towards the Indian election process law, and they are trying to follow also, and the judiciary played a significant role in strengthening the powers and functions of the Indian this election law. Because of this, what I say two things which requires your consideration. A power of the judiciary. Once the power, the independent and united judiciary, independent judiciary. So that is the need of the hour which we have. Our Indian judiciary, there is no match in the whole of the world. A postcard, the newspaper report is treated as a repetition by the Supreme Court and the High Court. This power is not available in rest of the world. So we must feel proud of our system, a democratic system, and our judicial system.
To the momentum to the speaker. Dr. P. Ratnaswamy. Dr. M. Asad Malik. Mr. N. V. Krishna. Mr. N. V. Krishna? Yes, sir. Yes. Now I will thank
someone. No. Yes. Thank you.
उधर से ले पक्का नहीं आया उधर से वो यार आपका उधर मेरे को बेकार है बाड़ा है नहीं
Today what happens, as you told that today now our country faces tyranny of major. So let the judiciary then stand up for the rights of the minority. Because the majority, democracy crudely defined is the rule of the majority. That's crudely defined democracy. But
here from a small country in Micronesia called Palau. I've been there for about 2.5 years, and before that I was a federal prosecutor in Washington, D.C. So that's my background. I've been asked to talk about judicial reforms in developing countries, and I've been asked to chair this in the hopes that we do not go over our time. I think what I'm going to do is cede my time to the next speaker, and if we have time at the end, I'll give my presentation. All right? So let me first start with our first speaker. Right. So let me cede my time to our first speaker, S. Prabhakaran, the president of Tamil Nadu Advocates Association and the vice chairman of the All India Bar Association.
Our first speaker is a co-chair, Mr. S. Prabhakaran, President Tamil Nadu Advocates Association, Vice Chairman, All India Bar Association.
And ladies and gentlemen, all persons shall equal before law, and everyone should have access to the courts. Any person should have the opportunity to defend his rights, and everyone shall be entitled to fair and a public hearing by a competent, independent and impartial court established by law. These cardinal principles are based upon the universal principle. It draws upon the historical experience of many lands. It is impossible to ensure the rule of law upon which other human rights depend without providing the independent courts and tribunals to resolve. The alternative to the rule of law is the rule of power, which is a typical arbitrary and self-interested and subject to influence which may have nothing to do with the application of law or the factual merits of the dispute. Without the rule of law, the assurance that comes from the independent decision makers, it is obvious that the equality before the law will not exist. Uniformity, consistency and certainty in decisions will be an accidental one. The achievement of the manifestly disinterested, the impartial applications of the legal rules will not be a feature of such a society. The constitutional provisions of a judicial branch of a government and the formal assurance that it is separate and independent of the other branches represent the main way by which most states seek to comply with the above principles. The judicial branch does not the typical include all those who, in a given society, make a decision by applying the pre-existing law to prove facts. Nowadays, there are many tribunals, statutory decision makers, and others who have that the responsibility. Nevertheless, a constitutional statement guaranteeing the independence of the judiciary is a good start. Symbolically, it involves an endorsement of the principles and makes departures from them far more difficult because they will need to be more public. Total separation of the judicial power is not possible in the real world. In many countries, the executive government appointment judges. The legislature provides for their salaries and pensions. It funds the activities of the courts. It is not necessary to be a sophisticated investor in Hong Kong or world-weary liar in Australia or the United States to realize how important it is that the conflict, serious enough to come to formal decision making in a court, should be resolved by a decision maker who is competent, independent and impartial. Even a person living in a most primitive society will aspire to that objective when confronted with the need to approach a decision maker. A judge without independence is a charred rat in a Pharisee inside an operations. See, this area is the more important. What we do here in our India, as far as in India, the collegium system we are following now. Whether it could be success in the collegium system, we do not know, because after the 1993 judgments by the Supreme Court of India, in earlier occasions the judge's name will be opted by the government, and the same way the Chief Justice also recommended the name, the appointed has been made. After 93, the collegium has been formed a committee, thereafter the collegium has recommended, then that is formal by the government of India, now the appointment has been made. Whether this system is a good system or is the earlier system is a good system, which is one good one, I am giving to the lawyers, members of the legal fraternity to look into these aspects. Because why should I say, in earlier 1993, the appointment was made by the judges. Of course, to some extent, we again acceptable one. But what is in the 2010, the recent past years, we have to look into it, the appointments of the entire in India, in all the high courts, how the modus operandi has been doing now. The relatives of the judges, number one, the relatives of the Supreme Court judges, the relatives of the concerned courts, and these people, and then the kith and kins of the government hierarchies. These persons have been appointed in many occasions, repeated past, since 2000 to 2000, past 10 years. It's going on, and many occasions judicial accountability we have been drawn in. In earlier occasion, the one sessions we have spoken in London in last year, we specifically pointed out in many countries, that especially in India and like in other countries in Britain and all, when the appointment has given to the judges to appointing as judges, this area is very dry, because the first the relatives and then the close associates with the judges and then friends of the judges. These persons are appointing nowadays. We see certain issues we have to openly, we have to frank and then discuss that, take into discussion. The person who is having a knowledge, the person who is having a capacity to deal with the law, whether they are having an opportunity to appoint as a judge, absolutely not. So, if so, then what is the relevancy to bring into the judicial reforms in that too, especially in a developing country? How to the operation has been made? When we have to follow the other countries now the situation has been the appointing the judges of the other countries. These and all we have to look into these areas. That's why we are repeatedly from since many years, that is especially since 2005 onwards, we are insisting the appointment made by the government, it's wrong. Appointment made by the judges, that is collegium, even that also not satisfactorily. If this be the circumstances, then who has to give? If the judicial forum has to formulate, we do not know. In earlier 1993 judgments is override, then only we can go into, otherwise it is not possible. Or otherwise you have to bring into the enactment by the parliament, then we have to do what is the satisfactions has been satisfactorily by the Supreme Court, that you have to do it. Whether these questions are all is a question even till now, nothing has been satisfied by anyone. The conversation which must supplement the textual impressions, assertion of judicial independence, reach deep into the history of each people and each legal system. In the countries of the common law, the judicial independence are received important constitutional reinforcement when the King James, he told in number 2 of England, second England of was driven, from the kingdom is the glorious revolution of 1688, his successors William and Mary were only accepted by the people on condition, amongst other things, that they promised to respect the tenure of the judges, essential to their true independence of mind of action. Suppose if comparatively those it is in Britain it is done, then if this be the circumstance, what is the formulation you are forming in India? Nothing, nobody knows. So therefore why we should include, even the James Millans say, James Madison's while drafting the amendments of the United States Constitution, which become the Bill of Rights of the country, asserted, independent tribunals of justice.
Excuse me, you have 1 minute,
Yes. Will consider themselves in a peculiar manner guardians of these rights. They will have impermeable bulwark against every assumptions of power in the legislative executive. They will be naturally to resist every encroachment upon the rights stipulated in the Constitution of Declaration of Rights. So, some political scientists on the basis of experience, medieval period of the time of the colonial rule, in a particular continents of Africa and Asia, would describe the system of governance. The marrow of all history is the patience with the men and women submit the burdens of unnecessarily laid upon them in their governments. See, finally, even before concluding my speech, the good governance entitled the effective participation in the public policy making, the prevalence of the rule of law and independent judiciary, besides the system institutional checks and balance through horizontal and the vertical separation of powers and the effective oversight agencies. Democracy, liberty, the rule of law together represent the torquia that the universal accepted now as the index of civil society. Democracy signifies a government of by and for the people. The protections of individual liberties follows the notion democracy not in corollary. Thus, these aspects has been looked into even in appointments of the judiciary in a developing countries. The judiciary in developing countries, including India, has been in the forefront for safeguarding the high values, cherished traditions of democracy. Judiciary is an institution has played a major role in shaping the public opinion and perception against all forms of injustice. What we have been seen before our eyes in Pakistan is a glaring example of the institution of judiciary single-handedly safeguarded the interest of the common citizen that the country against the dictatorship. Our judiciary has also not lagged behind. It has been in the forefront fighting all the forms of evils as against the society, such as corruption, nepotism, favoritism, bad governance, and etc. People in the developing countries look upon only in the institution of judiciary as their lost hope to regain their rights. Thank you very much.
Judicial developments in developing countries, but our system is developing just like everyone else's. And I hope it will be of interest if I was to spend just a few minutes talking about the concept of the trial judge in the United Kingdom and the most recent developments. I'm sure it's the same across the world, but what do lawyers tend to talk about at lunchtime? In my long experience, the favourite topic is what makes a good trial judge. One who is invisible in the courtroom in almost every way is my own favoured analysis. Others take the view that a good trial judge does not believe that he or she owns the courtroom, but that he or she is merely a steward of that courtroom, which belongs to the citizens the judge serves. And it may be that these are the basic principles that ought to govern the development of the judiciary in any jurisdiction. As you may know, in fact I'm confident most of you will, in the United Kingdom, in the criminal courts where I practice and defend and have done for a long time, there are 13 judges, 12 laypersons, jurors selected at random, and a single professional judge appointed from the experience but perhaps case-hardened ranks of the practicing lawyer. And the theory is the law for the judge, the facts for the jury. That's the division of responsibility. And that division of responsibility is not supposed to become confused in any way. I'll come back briefly to the division of responsibility shortly. In the United Kingdom, recently, by way of judicial developments, the Lord Chief Justice has decreed that judges must be responsible for far more rigorous case management, effectively to take the case from the scruff of the neck at a very early stage and to keep control of it throughout. And indeed, it wasn't more than a couple of weeks ago that a declaration was made to all judges, and I myself sit as a part-time judge, so it was directed to me also, to impose a timetable in every criminal trial for every aspect of the case. So before the case begins, the prosecutor is given 20 minutes to question the main prosecution witness, the defence, 15 minutes to cross-examine, and so on for other witnesses, and so on for legal submissions, closing addresses, and so on throughout. And of course, the more complex the case, the more substantial the issues, the wider the discretion of the judge. Furthermore, as the authorities have developed and the role of the European Court has become more influential, in each and every case, on each and every issue, the judge is required to give a detailed and reasoned ruling. However trivial the argument on any question of admissibility, the days, and they lasted a long time, when judges were permitted merely to utter the words, "I'm against you," and move on, are long forgotten. And in accordance with European principle, we and judges in the United Kingdom must give reasons on every issue. The judge's principal role is that of summing up to the jury, so back to the division of responsibilities, where the jury determine the facts, where the judge must give a full-blooded legal direction on every aspect of the case, and sometimes there may be 20 legal issues which require legal directions, and where the judge is also required to, and I say required, not empowered, to give the jury a detailed summary of the evidence, quite different to the approach, of course, across the Atlantic, and furthermore, to comment on that evidence, provided the judge tells the jury that that comment isn't binding. And this is the basic framework. And once again, over recent years, there has been a substantial body of judicial comment on these matters. Judges are now far more restricted in the ambit of comment they're entitled to make. They're required to give far more detailed legal directions. Their summing up is far more open to criticism in the appellate courts than it ever was in the past. Judges in the United Kingdom are, of course, appointed as being wholly independent of the executive. They're appointed by the Judicial Appointments Commission in an allegedly transparent and, I have to accept on the whole, genuinely transparent process. This is in stark contrast to the serious criticism recently made by former law lords, particularly Lord Hoffman, renowned for his human rights philosophy in respect of the International Criminal Court, where it's said that appointment of judges is totally opaque and where judicial qualifications for appointment to that court are effectively non-existent, whereas in the United Kingdom, many years of legal practice is an essential, as it is in other jurisdictions where respectable judicial systems operate. Judges are strictly monitored in terms of any abuse of power. This year there have been 2 cases in the Court of Appeal where judges have been severely criticised for criticising the Crown Prosecution Service for bringing a case. One case, the judge said that he didn't believe the case should have been brought before the court. On the other, he said, I don't want my court time wasted on rubbish like this. And in both cases, it was made clear that judges should effectively mind their own business where the instigation of proceedings are concerned. contrary to how it used to be in my early years as a barrister, where judges tended to treat defence counsel as being more culpable than the defendants themselves, in the modern day, the Court of Appeal will not tolerate what was recently described in the Court of Appeal as the judge acting as a second prosecutor. Animosity towards counsel is a thing of the past. Judicial comment about counsel to the jury and counsel's competence and so on is a long forgotten concept. And so moving, for fear of myself being on the receiving end of strict judicial boundaries, which have already been exemplified once, let me just move towards the conclusion of what I'm going to say. And I just want to come back briefly to the jury system, because it may, I hope, be of interest that in the United Kingdom recently it has been evidenced compellingly that the public are as strongly in favour of trial by jury rather than trial by judge as ever before. In fact, the last government implemented for the first time in 400 years the right to trial by judge in cases where there is evidence that the jury may be intimidated by serious criminal or criminals to the point that no fair trial could take place. This was greeted in the media by headlines such as an attack on the rights of the public, an assault on the standing of every citizen. We now have a mockery of justice where a judge, a case-hardened, paid-up representative of the Crown, will determine the outcome rather than a panel drawn at random from society, was the response. A Ministry of Justice report this year compliments juries in many respects, not least on a widespread national statistical analysis on the ground that there is simply no evidence of any racial discrimination, that all white juries are as liable to convict white defendants as black or Asian defendants, that juries reach verdicts on logical bases in almost every case, and that the myth that there are geographical discrepancies in the approach juries take to cases is not well founded. Whereas judges have been on the receiving end of significant criticism by the Lord Chief Justice himself, who says that they must come into the 21st century, that they must give juries much clearer directions on modern day forensic bodies of highly technical evidence, that they must guide juries far more stringently, that they themselves must use visual aids and computer-typed equipment rather than simply reading from their notebooks and operating in what one Court of Judge recently described as Dickensian fashion. In fact, Lord Justice Moses, a very senior appellate judge, in a lecture last week, himself launched a scathing attack on the trial judiciary. I don't suppose he'll be very welcome at Lincoln's Inn lunch hall after Christmas. But anyway, he said that the glory of English law, well, we seem to have hit upon a system designed to ensure that in all but the simplest of cases, the path we require juries to take should be obscure, tortuous and arduous as could be when it comes to judges' functions as a guide to the jury. Yes, I'm almost there. In fact, I'll finish within a minute. When it comes to judges' functions in guiding the jury, they are by no means as competent as when they themselves exercise individual judicial responsibility. So that is, I hope, a quick race through the judicial structure and significant judicial developments. And as I've already indicated, I certainly don't want Mr. Justice Foster to make a ruling against me, so I'm going to finish approximately 10 seconds early. Thank you very much.
Dr. Uday Shankar, Assistant Professor of Law, Rajiv Gandhi School of Intellectual Property Law, Indian Institute of Technology, Kharagpur.
Mr. Prabhakaran, Mr. Jarmijan, and Mr. Rajiv Pandey, and ladies and gentlemen, it's my pleasure to present my views on need of independent and reflective judiciary in India. For this gathering, I'll be speaking on the need to have a reflective and representative judiciary in the light of changing role of the higher judiciary. The scheme of the presentation would be, I'll be first speaking on role of judiciary, then the composition of judiciary, then the debate which I'll be presenting before you how it has been institutionalized, and the justification of the need of reflective judiciary. Instances are present before you, and the debate between merit and representation. And then obviously I'll conclude with few concluding remarks. When you talk about the role of judiciary, traditionally speaking, judiciary has been involved, or rather evolved, in settling disputes between two litigating parties in accordance with law. That's what is the traditional role of judiciary, and that's how we understand judicial role in the setup of the governance. To take it further, the judiciary, that to higher judiciary, also examines the validity of law in accordance with the Constitution. And the higher judiciary is also the final interpreter of the Constitution. And being the final interpreter of the Constitution, judicial action necessitates promotion and protection of social and economic values, political values which are scripted in the Constitution. That's what the judiciary need to keep in mind as final interpreter of the Constitution. And to execute this responsibility, judiciary must be independent and neutral because of the nature of responsibility entrusted upon this institution. And because of that nature, it is essential also to have a composition which befits the responsibility entrusted upon it. And that's why it is said that judges who constitute judiciary should be of right caliber and are known for their integrity and independence. So that's why the appointment of judges must be apolitical and uninfluenced by extraneous factors. And in that light, it becomes very significant to see that who are judges, what is the composition of judiciary, because judges, they do involve in expanding the meaning of individual rights and also to furthering the social goals which are there in the Constitution. And therefore, the social fabric of a country has a very important role to play in the composition of judiciary. And more so, this role becomes more important when, after second and third judges case, which has been briefly referred by Mr. Pravakar, the authority to appoint judges has been practically shifted from executive to the judiciary. Now it is the collegium which decides who will man the higher judiciary. That's why it is very, very important that what and how the composition of judiciary should be. And more so, it becomes more important and relevant that nowadays judiciary is engaged in social justice, social transformation, and that's why it raises a very important question of internal aspect of independence. And when I say internal aspect of independence, what I mean is that whether the composition of judiciary can rightly understand the pain and suffering of the millions for whom the governance matter the most. And that's why this judicial excursion into social and economic issues invites a debate on reflective and representative judiciary, which is essential for faith and confidence in the judiciary. And when I say reflective and representative judiciary, I am not advocating here reservation in judiciary. I am just saying that if you have a meritorious person there on the bench or in the bar, you must consider them, collegium must consider them to elevate to the higher judiciary. So nowhere I am advocating having reservation in judiciary, but I am certainly advocating to have a reflective and representative judiciary. And when I take this debate, if you look into the instances, you'll find that debate is institutionalized. I read a news report. It was reported in the Indian Express when Justice K.G. Balakrishnan was made Chief Justice of India. The report goes like this, that the new CJI, K.G. Balakrishnan, who was sworn in today at ceremony at the presidential place, is the first Dalit to make it to the pinnacle of the judiciary. And then, when Justice Gyansudha Misra, she became the judge of the Supreme Court, she said, I feel that I am representing women folk in the Supreme Court. I feel happy that the CJI and other judges in the collegiums have reposed faith in me and in the ability of women. If you read this, and if you read in between line, I see these news reports appearing in the media, educate us on our identities and inform us about the reality of the Indian society. And similarly, if you look into the other reports of scheduled caste, scheduled tribes Committee on the Welfare, parliamentary committee reports, they have such a committee report, they have echoed the similar sentiments that we need to have representation of those who are unrepresented in the higher judiciary. Again I say, this is not a case of reservation in judiciary, this is the case where we have a meritorious people, they must be given representation in the higher judiciary. Why it is important? Because it is important because they are involved in not only settling the disputes between two litigating parties, their involvement is more than that, to the extent of setting the policy matters. And that's the reason why I say that there is a justification for this. And the justification is that they are no more engaged in dispute settling, they are engaged in policy making. So much so in the recent judgment of 2010, between the disputes between the Ambani brothers, the court made to say, court said that in the matter of extraction of natural resources, the government must involve or engage public sector undertakings. This is nothing but a policy statement given by the Supreme Court, because it was nowhere in the dispute that how this excavation or exploration of natural resources should be taken place. But that's what the court, remarked. So this is what is the court has been setting the policies. And for exercising such power in democracy, the judiciary must also have similar, if not the same, justification as the other two organs of the government. And other two organs of the government, as it is well known, is executive and legislature. So the need of reflective judiciary also is stemming up from the fact that the role of representative executive has been reduced to stamp the recommendation made by the collegium in the matter of the appointment of judges in the higher judiciary. And the judiciary as a branch of government, not merely a dispute resolution institution, requires composition on social pattern of the society. Taking the justification further, judges decide the cases upon background understanding based on fundamental values of the system. And if the judiciary is not reflective of society as a whole, the adjudication may be based on the background understandings strongly colored by narrower set of values. So that's why we must have representative judiciary. And if I can further strengthen my argument by presenting few stances before you, if you look into the interpretation of equality clause, that is Article 14 of the Constitution in 50s and 60s or till late 70s, you'll find that it has been more tilted towards the American jurisprudence, giving more primacy to the rights of individual than rights of community. And that's why directive principles were not guiding the judiciary in interpreting equality clause, because the interpretation was more influenced by American jurisprudence of liberty, American jurisprudence of giving more emphasis to liberty or freedom. And that's why the larger goal of common man was ignored while interpreting equality clause. So that's why it is important to understand that those who are sitting on the bench, their background really matter when they decide the case, when they decide the issue at hand. Adding one more instance to it, in the famous case of Government of Andhra Pradesh versus Vijaya Kumar, wherein the case was related to the validity of reservation for women in a public employment, the then Judge Justice Sujata Manohar validated reservation for women in public employment under Article 15 Clause 3. As it is a gathering of legal luminary, I need not elaborate upon it, that Article 15 speaks about all other state activities except public employment. So when we talk about reservation in public employment, it is only Article 16 which guides the legislature to provide for reservation. One can very well infer this, that judgment had come because of the fact that there was a lady judge sitting on the bench. Had lady judge not been there, it would have been very difficult to imagine that the court validating reservation for women by taking 15 clause 3 into account. So it certainly reflects that background matters, and it is there is no denial of the fact that Justice Sujata Manohar, being a woman, understood the need of women empowerment, and hence he validated reservation for women under Article 15 Clause 3. So these are some instances which establishes the fact that why we should have representative judiciary, why we should have reflective judiciary. Then there can be another added argument, that how do you reconcile merit and representation? Because the moment you say representation, somewhere you negotiate with merit. I am of the view that merit is not a luxury when you talk about the appointment of judges in the higher judiciary. Merit is constitutional requirement. So in no case merit should be ignored. But adding to it, it is important also to understand that merit itself is a qualified expression. You cannot have any objective definition of merit. And if it is qualified expression, it is not possible to have very absolute content what merit means.
It's a mandatory.
It's mandatory. So merit is not non-negotiable. And that's why the governing factor of merit is not constant and changes with requirement, and it changes with requirement of time and place. And in the, I believe that the chairwoman who will be guiding me for that. I think we should leave that role for the chairwoman to do that.
We are leaving, but we are also listeners here.
Sorry?
Kindly we have also to ask, because this matter is for the reform, not for the sake of the generation.
Please continue. Please continue.
Please allow the
In
speaker.
the lead such views and be fully supported.
Please allow the speaker to speak. Mr. Chairman, am I allowed to continue?
You have 4 minutes.
4 minutes? I think 4 minutes is more than enough to finish my speech.
Thank you.
I continue with this, that nowhere I am arguing that merit should be alone has not been criteria always, and as it has been pointed by numerous law commission reports, along with merit, regional representation was always the criteria, that so that Supreme Court should be manned by people from all the regions. So let's not forget that regional representation has always been the criteria along with merit. So when regional representation can be a criteria, I believe there is nothing wrong in advancing the argument to make our judiciary more representative and more reflective on the basis of social pattern. So, but at the same time, I must clarify here that after the appointment to the bench, judges are expected to be completely independent and to express no overt bias toward the sectors of the society from which they originate or effect. So there must be a representative judiciary, but they should not remain representative of the group or the sector to which they represent. So they need to detach themselves when they are involved in a judicial exercise. And interestingly, if I have to make an observation, when you talk about merit, appointment of a senior most judge as a Chief Justice of India itself is a dilution of merit, if I can take liberty of saying so. Coming to the conclusion, the obligation of advancing social goals requires a democratic judicial institution based completely on merit, so that independence of judiciary can be cemented with faith and trust of people. The court is a tribute of the makers of the Constitution, and in salutation of creation of such an institution, Collegium must walk a step ahead, or to make the judiciary a completely meritorious and truly democratic representative institution. To conclude, if independence of judiciary is a basic structure of the Indian Constitution, then the need of reflective judiciary is essential to keep that basic structure intact. Thank you. Thank you for it.
Our next speaker, Mr. Rajiv Pandey, Advocate, Bombay High Court.
First, I'd like to bring back this session to the topic of judicial reforms in developing countries. Except Mr. Prabhakaran, who is a distinguished leader of lawyers in Tamil Nadu, I think this session has gone to somewhere else. The reason is, what is judicial reform and what we are discussing? It's about the developing country. Who are the developing countries? I think India is a true picture of developing countries, like in Africa, China. But China we can't mention because China is what kind of country I am unable to say. There is no democracy, so only where judicial reform can be talked about a country who is a democratic country. So in India, many people have talked about the judicial reform, and some steps have been also taken. In the last decade, after 2001, I think the biggest judicial reform in India has been taken by no lawyer, no judge. It is taken by one Mr. Anna Hazare, he may be 10th fail, I don't know. That Right to Information Act was introduced by him in Maharashtra. And later on, central government has taken over that act in 2004, no doubt after diluting the main teeth of the act. So that is done by the central government.
Why we require judicial reform? First, what is judicial reform? In my submission, in my understanding, judicial reform is required to affirm the democracy in the country. If there is no judicial reform, like we have seen in our neighborhood, that is Pakistan, judiciary has forced the government, the military dictators, that you have to come back. Dictatorship won't work. What judiciary has contributed in India, that we have seen in 1975, 1977. But now today, why we all are talking about the judicial reform? The reason behind is this, that people have started feeling that we are unable to get the justice in the existing system. The biggest reason for that, in my opinion, we are always counting in every report what is per capita income, what is population and all these things. But what is per capita judge? So until we improve per capita judge, there cannot be any judicial reform. That is the basic thing. Because if per capita judge has gone up, then certainly the disposal of cases will be more. So that is the basic things. In my submission, that first we have to improve per capita judge. Then second thing, we have to see the cost of the litigation. Cost of the litigation has gone so high that a common man cannot even think about the approaching court. So after this judicial reform, we have to make government should be accountable that if a person is not in a position to afford the legal cost, he has to be provided the state lawyers, and lawyers should be paid by the state. The third most important, that any corruption and all these things you see very well in every newspaper, all judges and all these things, I don't want to comment. It comes from the origin. So we have to hit where is the origin, what is the appointment. Whatever is the appointment at lower judiciary, at least nobody can question that there is an entrance exam, there is an interview conducted, and then lower judiciary people are appointed. What about the higher judiciary? Before 93, at my learned friend Mr. Prabhakaran had said there was a system in government, this ministry was recommending, and then it was happening. Thereafter, collegium is there. If really we want to strengthen our democracy by judicial reform, then we have to democratize all institutions. In India, there are 4 pillars of the constitution. One is press. I have seen a laborer's son is also a very good press reporter and a big press reporter. I have seen executive, that a person who is a rickshaw puller in last exam only, he has become IAS officer. Then you see in technocrat, in IIT exams, you would have heard about the Super 30 in Bihar. All are rickshaw puller, cobblers, son are becoming IITians. Then executive also, whatever is the corruption I accept in the member of parliament, among member of parliament and member of legislative assembly, but democratization is there. Even a poor person can become MLA and MP, then why not about judiciary, higher judiciary? The main reason is that this is the monopolizing the things, that only few people, few relatives, few things, a complete transparency, and even the lowest rung of person should be allowed to participate in this. Many times we have seen, if a person is not speaking good English, he can become a very good judge. He can become a very good democrat. He can become a very good IAS officer. We have seen this. So, but in their case, I am from Bombay High Court Bar Association. We see how things are happening. In my, I wish to say that lawyers should come forward and raise this issue. My last is this, which is about not about the judicial reform. This is helping about some new acts. Some new acts in legislation has been done by the central government in view of the judicial reform, like Arbitration and Conciliation Act. You see, this act is so erroneous, so oppressive. If suppose I am a small contractor and working with ONGC, if there is a dispute, there will be arbitration clause. In that it will be written, one retired retired judge of the Supreme Court can only become arbitrator. So I invoke arbitration clause. I appoint Mr. A who is ready to work for 1,000 rupees per hearing. ONGC appoints a judge who is saying, I need reading charge of 1 lakh rupees, then I need 1 lakh rupees per hearing. Then even my appointed arbitrator on the basis of parity, there are 3 arbitrators, it becomes 3 lakhs per hearing. So ONGC, if he wants to kill me, he will keep on adjourning the matter, and I will say it is better that I am withdrawing my reference. So the Arbitration Act is so erroneous that for the approaching High Court and Supreme Court, you have Court Fees Act, but for arbitrators, you are giving them power to judge their own fees. So these some good, I have just mentioned about the RTI, it is a good legislation, of course not as good as Maharashtra Right to Information Act, but at least there is a right of information, we can ask something. These kind of acts which are coming in force, we have to see very well that where it is going. If suppose a person is having dispute with Tata, can you manage the litigation cost? So what kind of this arbitration clause can be put where? If it is between Ambani brothers, it's all right. But if it is between a common man and Ambani brothers, then it's already lost. And they said that we want that it will be decided at arbitration, then there is a 34 appeal, then there is a division bench appeal, and then there is a SLP. Then where is the question? Then it is better at least our courts are getting money by way of court fees. It is better. Then you appoint more judges. I have written an article also some time back that these all tribunals and all, you appoint more judges, make in the place of 25 High Court judges, make 50 courts, make 100 courts in one state. So I think for judicial reform, with accountability, number of courts and the appointment procedure can really start the judicial reform. I don't know where it will go. And then the acts which are really just and fair, that should be done, not like Arbitration Act and other things. And if Arbitration Act is there, there should be a cap of fees like Court Fees Act. Now, what is in my conclusion, I wish to say what we have to do for judicial reform. In my opinion, there is a line of Sahib, "Jab girenge ye mahal, tab banenge naveen ghar." When this all forts has to be demolished, and I think something has been started. The moment this all forts are over, then the new small house of the common man may come, and hope that judicial reform will succeed.
Now, I request our chairperson, Honorable Ms. Justice Alexandra F. Foster, Associate Justice, Supreme Court of Republic of Palau, to speak on the topic.
Let me just tell you, Palau is a very small country. There are 20,000 people in the whole country. So understand that what we do in Palau may not necessarily be applicable to what you do in India. But I think that there are a couple of things that you may take away from it. We have recently passed an order called Special Order Number 2. The reason we've passed this order is because one of the big complaints of judges is that we don't issue our decisions fast enough. We sit on them, and we sit on them, and we sit on them, and everybody gets frustrated with us. So, in an attempt to self-police ourselves, instead of getting into trouble with the legislature, instead of getting in trouble with the media, what we have done is made a decision that we are required to issue our decisions within 60 days of the final either closing arguments if it's a trial, or the final submissions of statements like summary judgment decisions in the U.S. and the Palau system. What that means is that if we do not issue our decisions within 60 days of these final submissions, then we need to face a panel of our peers, 3 other judges, who will then, there will either be an investigation or not. Typically, this is a very black and white issue. Did you or did you not issue the decision within the 60 days? So if the decision was not issued, then the judge that has not issued that decision is now facing sanctions. In Palau, like in the United States and probably in many other countries, the only person or the only entity that can impeach a judge is the legislature for high crimes and misdemeanors, as well as it is in the United States and also in Palau. So you can't fire a judge, right? But there's 1,000 sanctions that can be imposed short of firing a judge. There's private censure, where you bring the judge in and you say, look, this is an embarrassment to all of us that we haven't been able to issue this decision within the 60 days. There's public censure, where you publish something with the local newspaper saying this is a problem and we blame this judge. Honestly, that doesn't really put the judiciary in a very good light, so we try not to do the public censure option. Another option is fines, to fine that judge until he or she issues the decision. There's also withholding the salary of the judge pending an issuance of the decision. Honestly, that's about as far as we go, and we haven't had to go that far yet. Judges, once they start to face the 60-day deadline, at least in Palau, and I would imagine in most places, issue their decisions, and they do so fairly quickly. So we haven't had to go to that final step of having to actually dock people's pay, but it is an option as a sanction. And soon after we issued the special order number 2, it made the front page of the newspaper. And I think the reason for that is that the people, the lay people, and also the lawyers, this is, at least in Palau, the critical issue is this whole problem of not being able to issue our decisions fast enough. And so it's important to the layperson to be able to see the judges actually do care and are willing to police themselves and to ensure that they move along a little bit more quickly. The other things that we've recently started to implement is questionnaires. And you may have already done this or been a party to this, but in Palau this is a first. So we ask questions not only of the lay people, but we also ask questions of the lawyers. And not only are the questions about the fairness of the decision and also the appearance of the fairness of the decision, but the questions are also about as to the lawyers, they're about individual justices and the demeanor of those individual justices. The trick, at least in Palau, definitely not in India, is anonymity. Because there are so few lawyers, the fact is that if you do a little bit of triangulation, you can probably figure out which lawyer is criticizing you and about what case. And so that's the main difficulty, and honestly, oftentimes in smaller countries, that becomes an issue. As I say, since most of my audience here is from India, I don't think I really need to spend a lot of time on that. But those are some of the main things that we have started to do as a judiciary in Palau in an attempt to have the people who we ultimately need to work with, have them respect us as an entity, as a judiciary. That's it. Thank you very much for having me.
Speaker, Mr. Uday Shankar, Dr. Uday Shankar, and I request Ms. Justice Alexander F. Foster to please.
Thank you.
Thank you so much.
Thank you.
Thank you, sir.
I'm Katie, I note it down.
I'll write it in my book when I get back. Anyway. Yeah. Go on. Yeah, I'll give you one piece of paper.
So it has 40,000 population.
20,000.
20,000?
Even smaller, yeah. 20,000.
Very small. So at what level you are working here?
I noted down my own numbers.
Oh, thank you.
How many levels are there?
I am author of certain books on accountancy and business studies.
Oh, right, okay.
Excellent. Only 2 levels.
Business management.
I will write this in my address book.
Oh, okay.
Yeah.
Your address is not there?
No, mine is here, but I'm saying I'll put yours.
I have my address.
Yeah, no, I will put it in my book.
Huh?
I will put this in my book.
Advantages, what it has to offer to judicial system in order to make the judicial system meaningful and in availing effective and speedier justice. Well, by information and communication technology, for my understanding, I'd like to say information and communication technology involves that machine called computer system which processes information, and
the connectivity between these computers, which creates what is called cyberspace, Maya Lok. And this technology is fueled by the other technology called internet. Well, all this includes, according to me, information and communication technology. Coming to the advantages information and communication technology has to offer, whatever be the field, be it education, commerce, small trade, big business, everything is affected by this information and communication technology. Affected in a better way. It has many advantages. It has made the life easy, information accessible, and the list of advantages goes on. Coming straight to what information and communication technology has to offer to judicial system. While we see on the one hand this new technology, information and communication technology, led to new breed of disputes like domain disputes, cyber crimes, and so on. Though it has led to new breed of disputes, the same technology has answers to resolution of these disputes, even other disputes. That is where I would like to make my contribution. Information and communication technology and its integration into judicial system so as to make the judicial system effective to offer speedier justice. In this direction, I would like to speak on two ways of integration of information and communication technology. One is integrating the technology for administration of courts. The other is integration of technology in dispensation of justice by the first, that is integration of technology in administration of courts. I mean, starting from replacement of old typing machine by the computer machine to hosting lot of information relating to the court on the website. So an infrastructure may be created starting from installing a computer, LAN connectivity between the computers, printers, and having a website, cause lists being posted there, information about the cases being posted there, and kind of things. This may go a long way in ensuring the functioning of the courts in a speedier way. For this purpose, information and communication technology be made use. The other important utility of information and communication technology. We should think of integrating this technology in dispensation of justice as well, which is the mental activity. In dispensation of justice as well, to a great extent, ICT can be integrated. That is where we talk of, and I'd like to introduce that terminology called e-courts, techno-legal e-courts. It's time now to think of e-courts, again to repeat, to avail the benefit of speedier and effective justice. By e-courts I mean making the courts paperless, starting from filing of petitions and plaints online, filing them online, processing them online, serving the summons online, investigation online through video conferencing, serving the summons online through emails which are digitally signed in order to ensure security, kind of things could be the way out. And one mistake, if I can call so, that has been done in the system is lot of investment has been made, commitment is shown by the state in integrating information and communication technology into courts. Mere investment and procurement of these machines is not enough. Integration shall happen in the form of in the form of procuring the benefits of it. in procuring the benefits, in proper integration, I have two things to suggest. One is, apart from investing and procuring the technology, that is machines, two things needs to be done. One is develop and create, or develop or create, proper software that is necessary for court functioning. Second,
codes and e-codes by my very learned predecessing speakers. And I can definitely take the advantage of building thereon. Let me begin by asking a question. Why at all does IT, information technology, have to have an application onto courts? Is it because computers are a fancy device? Or is it because dealing with computers and information technology is fashionable these days? Or is it because we have issues of space, which electronic records help us optimize space, wherein this hall full of physical paper hard files might really be just carried on in a pen drive? Or is it because of fidelity that a hard copy record can be tampered by a manual transgressor, whereas a digitally protected soft copy record, whether it be a sale deed or any other document, can become tamper-proof for years and decades together? These are some of the candidate reasons why e-courts are gaining popularity. And different jurisdictions in the world are responding to e-courts for different reasons. Some for fashion, some for space, some for fidelity, some for convenience, and some for speed, and some for more than one of them. The reason why I invested time in focusing on this was, you as responsible thinking jurists have to apply your mind, have to exercise your wisdom and discover your reasons in your jurisdiction which would be the best suited reasons for achieving the same. I believe while information technology is a blessing to court administration and also to justice dispensation, yet it poses its problems. Unfortunately, we are not prone to talk of those problems or of the negatives. However, it is important to be reminded of them. I beg to point out two such negatives or cons or grey areas. Do you remember, some time back, not really long ago, maybe 10 years down the line, there was a rule in different high courts of India and of other countries as well, that you could not access a judicial order, you could not peruse, you could not even read a judicial order in a matter in which you were or are not a party. That was the idea of privacy involved. So, that being the basis, that being the juristic basis of that rule, come down to the present times. In the present times, we have what we call as easy access to court websites. You type in Supreme Court of India, you get access to its website. You type in a certain criminal writ petition, you type in maybe a respondent or a petitioner's name, and lo and behold, you have that order before you. And you can read it, you can download it. At some point of frame, the idea of privacy vis-a-vis an ongoing adjudication has or is becoming a casualty. Either the court administrators need to awaken to it,
or we need to review and say no, that privacy, that idea of privacy was wrong, and we are now going to break those walls of privacy down, and it's going to become open and yet more open for everybody. The other issue, the other difficulty that can happen at times, but we should not overlook, is the difficulty and the possibility, which is thankfully not the probability, of an electronic system getting corrupted or crashing down altogether. If you do not rely, if we do not put in the mandate of modernization of our courts towards the e-courts, if we do not put on the mandate that yes, we necessarily have to have a hard copy kept in the registries respectively wherever and for whatever, we run the risk of losing in one go a huge amount of documentation, and with that a huge amount of adjudication done in the prior decades or years. And that can be a substantial loss both to administration of justice as well as to dispensation of justice and equity. These are two areas which I gave you as examples of where concerns on the negative side occur and happen and spring on us when we talk of e-courts and application of IT onto the judiciary. Next, let me share some thoughts of where we are today on e-courts. To begin with, I was amazed when I discovered that my fellow attorneys in Massachusetts were, majority of them, far behind in having access and competence vis-a-vis computer applications and vis-a-vis using computer hardware and applying it to justice, access and delivery. It is for some reason or the other, the mature generation of lawyers around the world, even today, are not as computer friendly as we think them to be. So all along, bar associations and jurists have to invest in e-training, in IT training of jurists and lawyers of the age that they are practicing in. The younger ones, of course, they are being equipped at the law school stage itself with all kinds of IT technologies. Today, e-courts are being used. In India, in Delhi, we have a whole e-court designated at the High Court, I understand. In California, it is only as late as 2008 that we started the system of electronic filing. In Los Angeles, it was only in 2008 that for the first time they started training their lawyers how to do e-filing and how to file petitions and look onwards into using that system. To my mind, e-courts are not the best when they deliver a summons in a fraction of a second. The idea behind summons is not the immediate delivery. The idea behind summons is to communicate information and then allow time for the summoned party to apply his or her mind and then come to the court. That is the idea. So the immediate delivery by e-courts of summons cannot be the very good reason. That can be only one of the many supplementary benefits that we get and we have. Similarly, the idea of e-filing is a matter of convenience. Any lawyer can file paper petitions, can also do e-filing. To my mind, the real next step onwards for e-courts will be when we start using what you younger people call as chat platforms for using adjudication, which means a learned bench will sit in the courtroom with two monitors in front of it. One monitor will have PDF documents displayed on it, annexure so-and-so, sale deed so-and-so, this, that, etc. The other monitor will be a live chat platform. On that, after confirmation of a digital signature, the learned advocates of either side, the attorneys of either sides, would be permitted by the court administrator, the IT administrator, to log in. Supposing some advocate is sitting in London and doesn't want to miss this hearing, he can opt for this kind of a e-court, as I call it, as a true e-court. He would log in into a chat platform, and then the other counsel, even if he's sitting right there in the court, will be required to type in his argument as it flows. So we have two screens for each of them. One screen displays the documents on PDF. The other screen is a live chat platform, like you have the MSN chats and whatever you do. The only difference being that these will be more secure, these will be of restricted entry, and that is when, I dare say, true achieving of e-courts would happen. That is the next major step forwards which we should look to. My firm, the Constitutional Law Laboratory, is now setting up an inter-university center for legal research and solution crafting. What we are doing is one of the activities is we are devising platforms for e-courts, and we look forward for these platforms to be of greater use in regions which have poor connectivity, in third world countries which have poor connectivity, which have lawyers spread out in the country, and it is not always convenient for everybody to gather together. And more often than not, also for witnesses to be able to have a witness testimony delivered right sitting in her home in a village, in a village of Ghana. An old lady is able to depose under the watchful eyes of a court-appointed local commissioner. And that deposition comes straight onto the bench in the form of its e-courts. These are the applications of e-courts that I do look forward to. And my experience of the Inter-University Center devising these has been happy. We are finding people who are trusting it. There was a generation when the electronic voting machines was mistrusted by most voters. Today, voters trust it. Similarly, there will be very soon a time when the most less literate of litigants would be able to trust e-courts of today and hopefully of tomorrow. I thank you.
For a moment of presentation.
Before that, I think I'd like to add, because that has been asked. You perfect. Yeah, please continue. Yes. Currently, I am also the General Secretary of the Indian Academy of Forensic Medicine, just for the sake of introducing myself. Regarding the comments of the first speaker, this summons, the serving of summons, I think that will be a great step, because we as a doctor, we face a lot of difficulties while receiving all those. Then afterwards, the fourth speaker also told that it will be very convenient for us. And not only that, further that also, when we are submitting the copies of the medical legal reports and post-mortem reports to the Honorable Court, because we have got the fully computerized center at AIIMS, right? So we will be sending it to the court as well. So in that way, we will be saving a huge amount of money, and it will be much convenient to everyone. I, being the medical records section in charge, I propose this because, see, for all this, we need someone from the judiciary who is here who can expedite this. We have got our disposal, facilities at our disposal, but how to proceed in this matter? After a lot of efforts, only this last month also, this process of this appearance of the doctors was specified. Previously, doctors were used to call at 10 a.m., they used to sit at up to 2 p.m. and afterwards the evidence used to start. It was a huge loss of the precious professional time. The Honorable High Court of Delhi District Session Judge, he took cognizance of my petition and he issued a specific order that now onwards the doctors will be called from 2 p.m. onwards. So all these steps are necessary. So I request Dr. Adish Aggarwal to please incorporate in their finding that yes, at least in Delhi we can start. We have already got e-court. Now yes, yesterday there was a news that online FIR will be there. Every police station has to make an online FIR. So that will be one step, and at least we can have a model center at Delhi. Afterwards we can spread to whole of the India. So it will be reciprocal. So that is from the suggestion from forensic medicine, because that will ease a burden from, lot of burden from us also, where the professional time will be utilized properly for the patient care services. Because for us it's basically only helping for the judiciary, but in that way our much time is lost for that. So I request this recommendation from this platform to make it for the recommendation of this conference. Thank you.
Pradesh, and now I'm for Haryana and Punjab. Every state government is facing these problems because mostly all these road accidents, murders, basically police bring the dead bodies or injured to the government hospitals. So much our doctors are earlier. They are supposed to come in morning and in the evening. Even up to evening their evidence was not being recorded and say now adjourned. So
most of the time,
so we have taken up every.
There is nothing specific. It was only for the proving of that regard. That is ridiculous. It then can be accepted just by the e-filing. Yes, this is the regard, you accept it. That's all.
No, I differ with you. There are two types of witnesses. Some are formal.
I am talking about the 90% cases of the accident and all that.
Because you have conducted the post-mortem.
Yeah.
That is a material witness.
Not that, yes, that's true. But at least 90% burden we can ease.
Yes.
Not on all cases, but 90% cases we can very much ease on the burden.
So we have always taken up the matter with the high courts, and high courts have issued directions to the lower judiciary that formal witnesses should not be called. If they have come, even defense counsel is not available, courts now they are not adjourning any matter because the defense counsel is not available. Court will record the evidence that I have brought such and such a record, this bears the signature of such and such officer, and court exhibit those documents. Earlier, even they were coming and going. So, now courts are also, once the state government take up this matter, and we have taken up the matter with the high courts, and high courts have issued the directions to the lower judiciary. But you see, in India is a very big country. Problem is, so sometimes our officers also want, because they want to come, because if they have been posted, suppose they were I'm not in Delhi, like a person, UP is a very big state, and if he is appearing in a case which was in Kanpur, when he was the CMO in Kanpur, and now he has been transferred to Gorakhpur or Ghaziabad, and he has relatives or he has his family in Kanpur, so he also requests if the matter should be adjourned and he can come and go at the government expense. So that mentality from our officers also, that is prevailing. So now things are improving. Government is also very sensitive. Courts are also accepting our request, and things are improving. So we meant to.
Thank you, sir. Mr. Dr. Amit Ludri to get a memento from Aggarwala.
He is very young. He is always doing wonders.
Now, Professor Malika Arjun Iyer. Professor Malika Arjun Iyer. Now, Professor Mr. Shams Khwaza. Sir, please get your moment. Mr. Ragul Sudesh. Please want to ask any questions?
Why? Everyone is tired.
Thank you, sir. Wonderful business. Please, absolutely, my pleasure.